Check, 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 check. Check, check. So I think this is good. Yes. This is on. 1, 2, 1, 2. But it's here, right? Let me find out. I will let you know.
Tuishi kwa amani, tutimize na malengo yetu. Jumuiya
Good morning to you all. Kindly let's get to our seats. I believe we are ready to start, so I'll ask us to kindly stand up for the EAC anthem.
Mungu twaomba uilinde Jumuiya Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tuilinde, tuajibike, tuimarike. Umoja wetu ni nguzo yetu, idumu jumuiya yetu. Uzalendo pia mshikamano viwe msingi wa umoja wetu, na tulinde uhuru na amani, mila zetu na desturi zetu. Jumuiya yetu sote tuilinde, tuajibike, tuimarike. Umoja wetu ni nguzo yetu, idumu jumuiya yetu. Viwandani na hata mashambani, tufanye kazi sote kwa makini, tujitoe kwa hali na mali, tuijenge jumuiya bora. Jumuiya yetu sote tuilinde, tuajibike, tuimarike. Umoja wetu ni nguzo yetu, idumu jumuiya
Please take your seats. Honorable Judge President of the East African Court of Justice, honorable judges from the East African Court of Justice, the President of the East African Law Society, the President of the Rwanda Bar Association, the CEO of the East African Law Society, the representatives of the bar associations from our partner states, and all the lawyers present. You're most welcome to the inaugural East African Court of Justice Bar Bench Forum 2025. And this forum has been organized in collaboration with the East African Law Society, the East African Court of Justice, under the auspices of the Raoul Wallenberger Institute's Regional Africa Program. You're most welcome, this being the first forum. We look forward to very engaging and interesting discussions. The objectives of the Bar Bench Forum are to enhance dialogue and collaboration, strengthen implementation of ESCJ decisions with a focus on enhancing compliance by partner states, promote synergies and regional integration, explore creation of innovative solutions with the aim of enhancing the ESCJ's accessibility, efficiency, and effectiveness in the process of enhancing access to justice. This forum provides a platform for judges of the East African Court of Justice and legal practitioners from the region to discuss critical issues on the delivery of justice. Among the key topics for discussion today, we shall be considering strengthening the bar bench relationship, jurisprudential growth, that is the contribution of the bar and the bench to procedural and jurisprudential developments of the ESCJ, as well as assisting the court to enhance court efficiency for expeditious justice delivery. Our hope is that in the end, of which I have no doubt, is that with the continuation of such engagements, we will see a more independent and honest bench and a strong and vibrant bar. My name is Christine Mutimura. I'm Court of Justice. I will be co-chairing this forum with my colleague from the East African Law Society, Mr. David Sigano, who is the CEO. So with those few opening remarks, I would like to invite Mr. Sigano to make his remarks, and he'll give us more guidance on the program. Thank you, and once again, you're most welcome.
Thank you very much, Your Worship. The Honorable Justice Nestor Kayobera, Judge President of the East African Court of Justice, distinguished judges of the East African Court of Justice, distinguished judges from national judiciaries present, Her Worship, the Acting Registrar of the East African Court of Justice, Ms. Christine Mutimura, Mr. Ramadan Abubakar, the President of the East Africa Law Society, Mr. Moise Nkundabarashi, the President of the Rwanda Bar Association, all national bar presidents present. I believe we have all of them in the room. Members of the East Africa Law Society Governing Council, members of the Rwanda Bar Association Governing Council, representative of the East African Community Secretariat present, the Raoul Wallenberg Institute, our main partner, PALU, our other partner, senior counsel present, esteemed advocates and legal practitioners from the East African community, honored guests, ladies and gentlemen, good morning. It is my honor this morning to stand before you. I think this is an extremely historic event. For the first time in the court's over 20-year history, 25-year history, we are having a bar bench forum. And like Her Worship said, this is aimed at enhancing the collaboration, improving the relationship, and generally promoting access to justice for the people of East Africa. The East African Court of Justice has been the main vehicle, and recently, it has turned out to be the go-to institution whenever people feel aggrieved at the national level and they feel that they cannot access the justice they crave from national judiciaries. So we are very happy that this event is happening, and we are hoping to utilize it to enhance that togetherness between the court, and by this I mean the bench, and the bar. We want the bench to feel adequately appreciated in the role that it plays in justice delivery, and the bar to feel adequately heard when they are prosecuting their issues before this regional court. I want with this to thank the Judge President for allowing us to have this forum, and Her Worship the Registrar for all the hard work that has been put in terms of organizing. I equally want to thank the President of ELS for being the pioneer or the first person to urge us and say, David, we need this to happen, and we need it to happen quickly. And we are lucky that we had the third judicial conference here in Kigali. And with that, we learned not just the critical role of this court, we learned that we can take advantage of all the judges being here to also bring lawyers or the practitioners that appear before the judges. Unfortunately, we couldn't have as many people. We are lucky, however, to be virtual. There's a link, and we have people that are listening in online. So I want to also welcome you if you're listening to us virtually. This is equally your forum. We will give you an opportunity to raise questions. Probably you may not speak, but we will take your questions and they will be responded to in the course of this forum. My Lord, the Judge President, distinguished guests, ladies and gentlemen, I have interacted with this court at a personal level for over 10 years, and most closely for the past 8 years. And in the year 2018, and I want to be very practical with this, I took part in a study on the status of implementation of decisions of the regional court. And in that study, we didn't just look at status of implementation. We unearthed a lot of other issues that affect practice before the EAC court. And I want to share a bit on that, some of the findings that we got at that time, which are potentially still existing up to now. And we noted that one of the key findings was there were a lot of dismissals at that time on technicalities. And up to 20% of the 109 cases that we analyzed then had been dismissed on technicalities. That means 20% of the applicants did not get the justice they craved for, because for one reason or the other, their case did not have merit. And that came down on further analysis to a number of factors. The first one was the capacity of our litigants. Do they know what they are filing? Do they know the limitations in terms of time? Do they know what the court's rules of procedure are? So most of the time they'd miss a point or a step. And so the court had no recourse but to dismiss such cases on technicalities. And we sought to change that. I'll explain how we did that. We had 17% of cases at that time being dismissed on or for lack of evidence. So again, do our litigants prepare sufficiently? Does the bar know what is required to prosecute a case or to win a case at the ESCJ? Do they know how to adduce evidence properly before this court? Then we analyzed further data, and we found out that there was a bit of a challenge or a divide between the common and civil law nature of practice, which affected, to some extent, the quality of submissions, especially from the civil law system. I believe the practice is a bit different. Again, we sought to change that to make all litigants feel adequately able to appear before the ESCJ bench. And then we looked at another thing. How did the litigants coach their prayers? Because when you look at implementation, you realize that sometimes the court or the bench is forced to issue decisions in line with what has been prayed for. So did our litigants, especially the bar, know how to coach their prayers? What are they asking for from the court? And if you are asking for this particular award or remedy, is it implementable? So that also affected implementation, because then we were looking at implementation. So this forum and what we've done earlier seeks to bridge such existing gaps in terms of the bar and the bench. Then another thing that we found out, 7% of all references had sort of been withdrawn, mostly for want of prosecution, and that came down to a huge extent to costs. Litigants will file a matter from, say, Juba, and then they would not have the ability to send advocates or to prosecute the matter to conclusion. Basically, they cannot fly. They cannot pay advocates. And so the matter will just pend and go. Fortunately, the court has cured that to a great extent through virtual appearance. And for this, the court should be congratulated. Another finding that we had was the level of awareness of this court. I mean, a lot of the general public did not know what this court was and what its mandate was. In fact, to some of the over 700 people we spoke with, they would confuse it with the African court. And to some extent, some would confuse it with the former ICTR, now the UN mechanism. They would say that court in Arusha. To them, what comes to mind is ICTR. Or to them, what comes to mind is the African court. So the level of awareness among the general public was a bit of a problem. Among lawyers, you will be shocked to learn that most knew the court existed, but only a small number of lawyers knew what the court does, knew what its jurisdiction is, and knew how to approach it. So again, that was a big gap. And we took a number of steps. I'm happy the court took its own steps, especially on awareness. I believe the judicial conferences have been very, very successful. And again, for that, the court should be congratulated. There's a lot of awareness through the judicial conferences on what this court is, and there's a lot of support now to the ESCJ. So what did we do as ELS and with our partners like PALU, RWI, etc.? We entered into training and capacity building. In fact, over the past 4 years, we've trained, my Lord the President and my Lord the Justices, we've trained over 5,000 lawyers. I believe that is a very, very big number. Some of these lawyers, we've trained them physically. We've called them to rooms like this and taught them about the court. Some we've done virtually. And I believe, as we speak, as of last year, from the 109 references we looked at in 2018, we had over 400. And that was over 300% increase in the number of references filed before the ESCJ. I believe this one is very, very plausible. 300% increase. Not just because of our work, but because of the work of the court and other actors that have made the court very well known. And of course, the quality of decisions that have now been coming from this court. People feel more confident. I can get a proper remedy from the ESCJ. So again, we appreciate the court on that. We've generated publications. There's been judicial dialogues. The rules of procedure were reviewed to make them much more usable. Of course, I've mentioned hearing of courts cases virtually. But then we still have lingering issues, and those were some of the issues that we wanted this particular forum to address. One of the main ones is case backlog. I believe this forum should be able to find solutions to that. How do we make access to justice more expeditious? If I filed a matter today, can I be heard in the next 3-4 months? Or will it take 3 years or 4 years? We have issues of funding to the court. Of course, that directly relates or affects the efficiency of the court. We have the ad hoc nature. We need justices that can sit permanently in Arusha. The fact that you have to sit at the national level as a judge and then sit at the ESCJ, of course, makes it a bit difficult. And you have a lot to handle on your plate. Can we make that better? And many other factors that have been put on that program for today's forum. With that, my Lord the Judge President, honorable judges, and members of the bar, I wish to welcome you to Kigali. We will be handling logistics. In case you came on our ticket, the team is behind there. They will support you. They will probably collect your boarding pass. Please cooperate with them. Otherwise, I wish this particular forum success. I will be taking notes, and we shall hope to take the recommendations from this forum forward to the relevant authorities, including the leadership of the ESCJ, the leadership of the East African community, and national level, so that action is taken, so that they will see the bar has spoken. Thank you very much. Welcome.
Thank you very much, David, for those remarks. I'd like to invite the president of the Rwanda Bar Association, Mr. Moise Mundabarashi, to please make his remarks.
Your Lordship, President, East African Court of Justice, honorable judges from the East African Court of Justice, Mr. President, East African Law Society, colleagues present from the bar associations, ELS council members, Rwanda Bar Association council members, good morning. It gives me a great pleasure to join you this morning as we kick off this important inaugural Bar Bench Forum. Looking at the time the ESCJ and ELS has spent as regional organizations, I may say that such a forum is overdue. However, it's not too late to do what is right and catch up for necessary conversation that are going to help us improve on what we are doing as ELS and ESCJ. When it comes to justice delivery, the bar bench working relationship is very crucial because litigants access the court via the lawyers. As we are having this bar bench forum across the region, we are observing serious issues among the bar members and the bench. We have seen serious issues and insults that are spread on social media, especially like on X, among the bar members and the bench. The question then that we can reflect on as we are in this forum are as follows. How will the public keep confidence in any justice system when we justice actors insult each other on X? Can we find forums like this one to address issues of accountability and rule of law, which is a better way for people that call themselves land friends? If we can address issues we can't address issues among ourselves, how can we be sure or even be guaranteeing the public that we are going to resolve their matters? By saying so, I want to believe it's high time we revisit our codes of ethics as lawyers, but also on the side of the bench, revisit the accountability issues. Having reflected on the above, I want to commend the leadership of ESCJ and ELS because it has not yet reached at the level of the regional level. At least we are still having those issues at the national level. And but I also understand there are still issues between the bar and the bench at the ELS and the ESCJ to do with the quality of work that lawyers are doing, the knowledge of the court, and all other issues that are still prevailing. But I want to believe we still have room to improve on the same by making sure that we build the capacities. David has just mentioned that we have trained 5,000 lawyers, but I want to believe there is still a lot of work to be done. And we are capable of doing so. Since these kind of engagements are starting, I want to believe there is a room that we can have it as one of the recommendations, and we keep on making sure that it happens frequently. Such awareness and engagement are the ones that are going to help us address quite a good number of issues to do with, like, for instance, the fact that most of the lawyers in various jurisdictions do not use the court as should, but I still believe there is room of improvement. In the past, like the same way the CEO was putting it, ELS and ESCJ has done a lot to promote regional integration, not only in the capacity building, but we have also worked together to develop the jurisprudence and so on, which is a kind of work that is really needed to be commended. However, there are still a lot to be done. An example that is very simple is ELS this year turns 30 years, but we, the same lawyers, have failed to have a proper legal framework that has to do with cross-border legal framework, like a cross-border practice. Of course, technology has made it easy. I can instruct a lawyer in Kampala, I can instruct a lawyer in Bujumbura, but we, as a regional bar, have not been able to put in place such a legal framework, and I understand there are matters that are pending in the East African Court of Justice. I don't want to tell the court what they are going to do by the time they will be adjudicating these matters, but surely the fact that we have always hid ourselves behind these legal systems that are not ours to block this kind of regional practice, it's a shame on us. It's a shame on us. 30 years, we have failed to put necessary adjustment in place to make sure that there is cross-border legal practice. I want to believe this is something that we need to work on in such a forum, since we are talking matters regional integration, and revisit how we can do it better. Let me conclude again, Honorable President, by saying that It's really important to mention that the leadership of ELS and the ACJ have really done something very important. This gathering is going to be a good time to reflect and revisit what we are supposed to be doing to do better. Going forward, I want to believe this can be a forum that we can make annual. At ELS, we will do whatever it takes to make sure that we engage even the judiciaries from various jurisdictions, and we meet to discuss and engage to address even the issues that I've spoken about above. I therefore want to welcome you all in Kigali, and you can spare some time also to explore the city, but also get time to reflect on the matters regional integration that I've just mentioned. I thank you and wish you a good stay in Kigali.
Thank you very much, Advocate Moise, for your remarks. And we'll now get to hear from Mumbi, who will be here representing Mr. Chris Mudhuri, the Deputy Regional Director, Africa for Raoul Wallenberger Institute, who are also the sponsor of this event. Thank you.
I stand on existing protocols. Ladies and gentlemen, good morning. Good morning. Good. I wish to start by passing regards from our Regional Director, Africa, Ms. Raquel Lassen, and our Deputy Regional Director, whose name is on the program, Mr. Chris Muthuri. He would have been here but couldn't, and so I am here in his stead. That said, anything good I say should be attributed to him, and anything wrong I say is entirely mine. My name is Mumbi Maina. I am a program officer at the Raoul Wallenberg Institute. We are an academic and research institution based in Lund, Sweden, and we've been engaged in human rights capacity development since 1990. We have been involved through the Regional Africa program, which began in 2017, and we have worked for a long time with both the ELS and the East African Court of Justice, alongside other partners who I see some of them represented here. Mr. Donald there, I see you. In October, just last year, we began a new program focusing on monitoring implementation of human rights decision, and even in this new program, we continue to partner with ELS and EACJ, who have both been formidable partners. Now, the concept note shared by Mr. David Sigano noted that the bar bench relationship has been likened to Siamese twins. And I thought it interesting for us to reflect on some facts about the Siamese twins to draw an illustrative relationship between the bar and the bench. First, the Siamese twins or conjoined twins have presented scientists with the lifelong philosophical question of identity. In the more common type of Siamese twins, known as thoracopagus, the twins are joined at the torso and they share many vital organs, including the heart. Now, according to psychological theories, these are unquestionably two people who are sharing organs in the body. Two people sharing one body. But there is another type of Siamese twins known as cephalopagus, meaning they are joined at the head. meaning they share significant amounts of brain tissue. They can see through each other's eyes and they feel each other's pricks. And so the question usually is twin A separate from twin B, or are they actually the same person? This is not a biology class, but I think it presents the tension between the bar and the bench. Is the bar one with the bench, or are they separate? And what is the implication of the fact that the members of the bench actually come from the bar first? Bimal Prasad, a Nepalese advocate, took the view that if the independent judiciary is the pillar of democracy, the bar is the foundation of an independent judiciary. The bar is the mother of the bench and the bright mirror of the judicial officers whose image, character, and conduct are correctly and visibly reflected therein. And it is for the bench to nurse and nourish the merits of the bar. Now, the second fact about being in a Siamese relationship, and this one goes without saying, is that being a Siamese twin is incredibly uncomfortable. There are limits in what one can do. The idea of independence simply does not exist. Well, and the idea of independence does not exist unless, of course, separative surgery is used. Such, I believe, is the bar and the bench. While the bench is an independent body, it cannot operate independently from the bar, and neither can the bar operate independently from the bench. Joe Hamilton, a Supreme Court judge in Louisiana, said this in his 1960 paper titled The Ideal Relationship Between the Bar and the Bench. And he said this, and I open quote, "There's a relationship between the judge and the lawyer that exists in no other profession and in no other walk of life. It is very unique. The relationship is fraught with the hazards of tempers that sometimes seethe in the stormy billows of the courtroom, and of antagonisms that occasionally arise from the laws that must, inevitably, be sustained by one side as every legal battle ends," end quote. And Mr. Moise alluded to these tensions that exist between the bar and the bench. The discomfort notwithstanding, members of the bench are forever destined to litigate before members of the bench, and members of the bench are destined to only have eyes and ears for members of the bar. My third fact, my second last fact, is that the discomfort notwithstanding, there are many Siamese twins who have gone on to live very, very full lives. And they do this having defined what dependence and interdependence looks like for them. I found it very interesting to learn that the first Siamese twins, by their names were Chang and Eng. They were from Siam, which is now Thailand, hence the name Siamese. I learned that they both married and fathered a total of 21 children between them, despite being, conjoined. The bar and the bench relationship is not easy, and it's sometimes very difficult to define. But it has borne a lot of fruit in East Africa over the years, and it can bear much more as we nurture and foster its growth. The fact that we are here today is truly testament to that, and it's the hope that through very candid discussions and practical solutions, we can find effective and efficient ways of meeting our common objectives. On to my last remark about Siamese twins. One of the main questions that arise when surgical separation is being considered is the chance of survival of either one or both of the twins. And not merely survival, but rather the quality of life. In some cases, one has been sacrificed for the sake of the other, after being deemed more likely to survive. The questions are they better together, or are they better apart? Will one survive the death of the other? Will they have a rich life? And I think this question is not just for the Siamese twins, but for us too. This bar bench relationship. We have come together to dialogue because we do not just want to survive. We don't want to just merely coexist because we have to. We actually want to achieve results together. Like the original Siamese twins, we want to live a full life and make life. As Mr. Moise has also noted, the fate of the litigants depend on this bar bench relationship. There's a Swahili saying that goes, nyati wawili wakipigana, ni nyasi huumia. Literally translated, it means when bulls, is nyati a bull? Yeah? Buffalo. Yeah, when buffaloes fight, it's the grass that suffers. So let the litigants not suffer at the expense of our fight. As I conclude, it's a truly incredible honor to be a part of this event, this first of a kind event, and I'm looking forward to all the discussions that we will have. Thank you.
Thank you very much, Mumbi, for articulating why we are here. And I think when this forum was being convened, the main purpose was to remind us that we are actually better together than being better apart. And I believe that by the end of this forum, we will all be convinced of that. So I'd like to now invite Mr. Ramadan Abubakar, the president of the East African Law Society, to make his remarks. And I'll also extend the honor to the president of the ELS to invite the judge president to officially open this session once you're done with your remarks. Karibu.
Thank you, thank you. You know, when I walked in this morning, Prof. Sempebwa joked that I'm overdressed. But Judge Kadurima Minoti will tell you, in Kenya, when you appear before the superior courts and you're not dressed like me, the judges will tell you that they cannot see you. Therefore, Your Lordship Judge President, I beg that you see me today. Ladies and gentlemen, allow me to greet you with Islamic greeting, Salam Alaikum. But before I read my speech, I'm not here alone. Considering the importance of this event, I'm accompanied by the Governing Council, who I'll ask to stand up, if you don't mind. From that end, I see Mr. Mwaura Kabata, the Vice President, Law Society of Kenya, representing Madam Faith Odhiambo, the President of Law Society. Karibu Mwaura. I see Mr. Asimwe, the Vice President, Uganda Bar, representing the President. Karibu. I see Bwana Joseph, the President, Zanzibar Bar Association. Karibu. Next is Madam Irakoze, our treasurer at ELS from Burundi. Next is Mr. Tedros Getachew from Ethiopia. Judge President, East Africa Law Society, you can see is way ahead, the EAC, having incorporated Ethiopia into ELS. We welcome you, Ethiopia. Next to him is Mr. Arop, the President of the South Sudan Bar, the youngest bar in the region. Behind there is Mr. Patrick, the bâtonnier of Burundi Bar Association. I see TLS representative representing the President Mwabukusi. Karim. and of course our CEO, who is well known to you, Mr. David Sigano. The buttoner and our host, Mr. Moise. Thank you. Next to him is Mr. Seka, our SG at ELS. And right next to him, last but not least, is the Vice President, Mr. Masood Salim. Thank you. Your presence is appreciated. Honorable Justice Nestor Kayobera, Judge President of the East African Court of Justice, distinguished judges of the East African Court of Justice, National Bar Presidents present, members of the East Africa Law Society Governing Council, members of the Rwanda Bar Association Governing Council, representatives of the East African Community Secretariat and partner states, the Raoul Wallenberg Institute, represented by Ms. Mumbi Maina, senior counsel present, esteemed advocates and legal practitioners from across East African community, honored guests, ladies and gentlemen, good morning. I wish to welcome you all to this vibrant and beautiful city of Kigali. I am profoundly honored to have been the president that pioneered this historic Bar Bench Forum. To me, this gathering is not merely an event. It is a milestone to reposition the bar and the bench as twin pillars that define the future of regional integration and the administration of justice in East Africa. For many years, the narrative of justice in our region has been one of evolution, punctuated by challenges of pre-colonial wisdom giving way to colonial structures, of independence igniting hope, and of integration forging a shared destiny. From the Court of Appeal of Eastern Africa in 1909 to the rebirth of the East African Community in 1999 and the establishment of the East Africa Court of Justice in 2001, we have witnessed a journey of resilience and ambition. Yet, as we stand on the cusp of a new era, we must ask ourselves, are we truly harnessing the symbiotic bond between the bar and the bench to deliver justice that is swift, accessible, and transformative for the people of East Africa? The theme of this forum, repositioning the bar and the bench in defining the future of regional integration and the administration of justice in East Africa, is both a reflection and a summons. It reminds us that the bar and the bench are not mere actors in a legal drama. We are architects of a just society, custodians of the rule of law, and champions of a united East Africa. Our roles, though distinct, are inseparable, like the roots and branches of a mighty tree, drawing strength from one another to shelter the aspirations of over 300 million East Africans. Today we convene not to dwell on the challenges we know too well, case backlogs, procedural limitations, slow enforcement of judgments, or limited awareness of the court's mandate, but to rise above them. This forum, a pioneering collaboration between East Africa Law Society and the East Africa Court of Justice, is a platform for candid dialogue, bold innovation, and unwavering commitment. It is an opportunity to bridge the gaps between our mandates, to harmonize our practices, and to amplify our collective voice in advancing regional integration. As the East Africa Law Society, representing over 43,000 lawyers across this region, from the shores of Mombasa to the highlands of Kigali, from the plains of Arusha to the vibrant streets of Kampala, from the sandy shores of Zanzibar to the land of origins, that is Addis Ababa, we stand resolute in our mission. Since our founding in 1995, we have sought to ensure that the legal profession remains a vital force in shaping policy, upholding the rule of law, and fostering trade and governance. This forum is a testament to that vision, a space where the bar and the bench can forge synergies, confront limitations, and craft solutions that enhance the East Africa Court of Justice accessibility, efficiency, and effectiveness. To my esteemed colleagues at the bar, I say this: our advocacy is the lifeblood of justice. The quality of our pleadings and submissions, the courage of our litigation, and the integrity of our practice are the foundations upon which jurisprudential growth rests. To the distinguished judges of the bench, I salute you. Your wisdom, impartiality, and dedication breathe life into East Africa Court of Justice, making it a beacon of hope for citizens seeking redress beyond their borders. Together, we must address the pressing questions before us. How do we reduce delays and case backlogs to deliver expeditious justice? How do we strengthen the implementation of court's decisions to ensure they are not mere echoes in the wind? How do we uphold ethics and professionalism to silence allegations of bias or unfairness? And how do we secure sustainable funding and judicial independence to fortify this vital institution? These are not questions for tomorrow. They demand answers today. And this forum is where we begin to shape them. As we embark on a day of open deliberations, let us do so with a shared resolve to strengthen collaboration, to build trust, and to chart a way forward that leaves no one behind. Let us envision an East Africa Court of Justice that is not only a guardian of the treaty, but a cornerstone of regional unity. A court where every citizen, from a farmer in rural Burundi to the trader in urban Juba, finds justice within reach. In closing, I extend my deepest gratitude to our host, the government and people of Rwanda, for their hospitality and unwavering commitment to the East African community. I thank the leadership of East African Court of Justice, Your Lordship Judge President, our partners of the Raoul Wallenberg Institute of Human Rights and Humanitarian Law, and every participant here today for answering this call to action. Let this inaugural Bar Bench Forum be remembered not just as a gathering, but as the dawn of a new chapter, one where the bar and the bench stand united, resolute, and ready to define the future of justice in East Africa. With that, thank you, ladies and gentlemen. It is now my singular honor and pleasure to welcome the Judge President, Honorable Justice Nestor Kayobera, to make his remarks and officially open this forum. Welcome, Judge.
The honorable judges of the East Africa Court of Justice and the judges from the national judiciaries, Land Council Ramadan Abubakar, the president of the East Africa Law Society, Ms. Mumbi, representing Mr. Chris Muturi from the Deputy Regional Director, Africa, Raoul Wallenberg Institute, the partners, Land Council from the East Africa Law Society, members of the Governing Council from the East Africa Law Society present, our hosts, Land Council Moise Hundabarashi, the president of the Rwanda Bar Association, all the members present, esteemed legal practitioners, legal gentlemen, our registrar from the East Africa Court of Justice, distinguished gentlemen, all protocols observed. Good morning. I'm informed that the Attorney General and the government lawyers have not been invited. But I think also they are also from what? Yes. Yes, the government lawyers present. Yeah, thank you so much. Yeah, that's good. I'm grateful to be here today at the first East African Court of Justice Inaugural Bar Bench Forum. This event is a key moment for building cooperation and strengthening the vital roles of both the bar the bench in advancing regional integration and upholding the rule of law in East Africa. As we gather here today, we are reminded of the importance of dialogue and a collective effort in building a more interconnected, just, and integrated East African community. The theme of this forum, the positioning the bar and bench in the defining the future of regional integration and administration of justice in East Africa, speaks to the heart of our shared role in shaping the future of East Africa. The East African Court of Justice stands as a pillar of this wisdom, of this vision, a cornerstone upon which the principle of justice, fairness, and regional cooperation are upheld. I hear my brother alluded to serious issues and to issues. Serious issues and issues. But I think we shall be there. On the role of the East African Court of Justice in strengthening regional integration. At its core, regional integration is about bringing together diverse nations, cultures, and economies into a unified whole, allowing for collective progress and prosperity. The East African community, comprising now of 8 partner states, has made tremendous steps in nurturing economic cooperation, social development, and cultural exchange. However, the journey toward a truly integrated region is not without its challenges. One of the most critical pillars of integration is the administration of justice, and it is here that the East African Court of Justice plays a vital role. The East African Court of Justice was established to serve as the judicial body of the East African community, mandated to ensure adherence to the law in interpretation and application and compliance with the treaty. Through its interpretative and adjudicative function, the court plays a crucial role in ensuring the integration process remains on track, commitments made by the partner states are honored, and the rights and interests of the East African residents are safeguarded. In the judicial body of the East African community, the court plays an essential role in ensuring that the principles of good governance encompassing the rule of law are respected. The court's jurisprudence creates a clear and reliable legal framework for businesses, individuals, and governments. By interpreting the treaty and resolving disputes, the East African Court of Justice fosters a sense of fairness and equity that is crucial for building trust in the integration process. Furthermore, the court serves as an inspiration for the protection of human rights, environmental law, and the promotion of democracy and good governance. By holding partner states accountable for their actions, the court reinforces the fundamental principles that govern the achievement of the objectives of the community. As to the role of the court in upholding the rule of law, a strong rule of law is a cornerstone for any prosperous democracy. For the East African community, the rule of law is not just a theoretical ideal. It is the practical foundation upon which regional cooperation and integration are built. The East African Court of Justice's role is in ensuring the observance of the rule of law cannot be overstated. Its function is not only to interpret and apply the law, but also to uphold the principle of justice and fairness, ensuring that the rights of all East African residents are respected. From human rights violations to electoral disputes, the East African Court of Justice has played an instrumental role in ensuring that the rule of law prevails. The court's ability to adjudicate disputes involving partner states, organizations of the community, as well as the legal and natural persons, contribute to a more stable, just, and predictable legal environment for everyone in the region. However, the work of the East African Court of Justice in promoting the rule of law is far from complete. there remain significant challenges in terms of case backlogs, slow enforcement of decisions, limited funding, delayed disbursements of funds, and the low visibility about the court's role among legal practitioners and the general public, as well as the lack of administrative and financial autonomy. It is some of these issues that the Bar Bench Forum aims to address, providing a unique opportunity for judges, legal practitioners, and other court stakeholders to come together and brainstorm solutions that can improve the functions of the East African Court of Justice. As to the strengthening the relationship between the bar and the bench, for the East African Court of Justice to continue fulfilling its role effectively, it is important that the relationship between the bar and the bench be strengthened. Judges and the lawyers need to work together hand in hand, not only in the courtroom, but also in advancing the reforms that enhance the administration of justice. The forum, therefore, represents an essential step in bridging the gap between these two critical components of the legal system. By developing dialogue and collaboration between the bar and the bench, we can address critical issues, including case backlog, procedural inefficiencies, funding issues, enforcement of the court's decisions, and raising awareness of the court's role in the integration agenda. Furthermore, the involvement of legal practitioners in advising for the necessary reforms and challenges is important in ensuring that the decisions of the court are implemented and respected by all partner states. Number Majiwan. I'm sorry. The collective wisdom and experiences of both judges and the lawyers are essential in identifying innovative solutions to the challenges facing the East African Court of Justice. Together, we can ensure that the court is in a better position to fulfill its mandate of promoting regional integration and upholding the rule of law. As we plan for the amendment of the East African Court of Justice Rules of Procedure 2019 and the Arbitration Rules 2012, the role of the East African Law Society and other legal practitioners is key. A call for greater collaboration and support. In conclusion, the role of the East African Court of Justice in strengthening regional integration and upholding the rule of law is unquestionable. However, this role can only be fully realized through the collective efforts of all stakeholders, including the East African Court of Justice, the legal practitioners, the respective government of the partner states, and the citizens of the East African community. I call upon all of the judges, the lawyers, the policymakers, and the civil society organizations to deepen our commitment to the ideas of regional integration and the rule of law. Let us use this forum to forge stronger partnerships with mutual respect, share our experiences, and identify actual steps we can take to strengthen the East African Court of Justice. Through our collective efforts, we can build a more just, integrated, and prosperous East African community, where the rule of law is the cornerstone of our shared future. With these few remarks, I declare the inaugural meeting of the East African Court of Justice Bar Bench Forum 2025 officially opened. Asanteni sana.
Thank you, my Lord, the Judge President, and thank you for the very warm welcome to this session. I'm going to lead the next very short session, and this will usher us into our tea break. For the memory of this very first event, allow me, my Lord, the Judge President, to request you to take a few photos with the delegates in the room. We will take the photos at the back because it has steps to make it very easy. It should be a very quick process because we have some of our delegates traveling this evening. So we will try to hurry it up. The first photo is the bench, the whole bench. Allow me, honorable judges, to request you all to move to the back. The bench and the ELS Council. That will be the first photo. The next one will be the bench and the RBA Council. The third one will be the bench and our partners and facilitators. And the last one will be the bench and all litigants in the room. I will come to the back to just make sure we follow that.
Hello, hello, hello. Honorable judges and members, tea is served. Please let's take few minutes. We only take 15 minutes and we get back to our seats. Karibuni.
Okay, and another one from here. Damuru aza disconnecting y'intuzi yongera yisubiza cyangwa urabizi nawe kubikora cyegura iki ndabona ari muremure
umugozi ni muremure ndashobora bayisetinze hasi
tumanuka aha cyangwa tuzenguruka
On the side.
You
On the side.
But when he wants to speak, he can just come down.
And we'll probably need to move around.
Problem is we have two microphones, two mobile microphones, and this one.
We need two microphones. Because now this is open
Yes.
dialogue.
And the moderator?
In fact, even three.
Actually, we wanted 3 microphones.
Okay,
We'll move
okay.
up.
Two movable, they're there. But
Two movable and the moderator. He has to stand every time. Can't get a third one.
I was right.
On the conference package. They said, actually, remember we asked yesterday.
They said
The
it's,
conference
it's
package.
3, including it includes this.
No, let them. We can be clever and tell them we don't want this.
Yeah.
Take it out.
Yeah.
Just need.
Tell we need just 3 mobile. And no podium. Okay, that's find a way. Find a way.
Can we please take our seats? Please let us take our seats. We are already behind time. Our aim is to close this forum at exactly 2 p.m. this afternoon. Our next session is on strengthening the bar-bench relationship, and the key discussion points under this session include reducing delays and case backlog through effective case management, handling matters under certificate of urgency, and upholding ethics and professionalism in the ESCJ litigation. So the person in charge of this session is Mr. Don Dare, the Chief Executive Officer of the Pan-African Lawyers Union. Mr. Don Dare has been one of our key litigants at the East African Court of Justice and has a very good understanding of our mandate, our functioning, but also what is expected of members of the bar when appearing before the East African Court of Justice. So I will invite Mr. Dare to please take it on from here. Thank you.
My Lord the Judge President, my ladies, my lords, judges, colleagues, let me also stand on the protocol that was already established by David Sigano and others in the morning. And let me start by an observation, just an observation, which is a challenge to us at the bar that I saw when we were taking the photos. In the morning, when I counted everybody who was on the room, sitting on the conference tables, including our dynamic communications officer, Brenner, we were 29 men and 8 women. Way less than a third, literally a quarter. And this comes from us at the bar, because the majority of the people in the room are bar leaders. So it is about how we elect. Of the 8 constituent bar associations of the East Africa Law Society at the moment, only the Kenyan bar, the Law Society of Kenya, has a female president, Faith Moniao Kodhiambo, who couldn't be with us, but she sent her vice. And I think by and large across the region, it's been about 20 years before we've elected a woman president to any of the bars in the region. ELS started with a female president, the Honorable Lady Justice Solomon Balungi Bosa, way back in '95. And even for ELS, it was the first and the last. So I think this is a challenge on us at the bar to see how we elect. But even beyond that, in our law firms and our legal practices, to ensure that we expose both female and male lawyers to these international courts and tribunals. If you look at the institutional litigators at ESCJ, for instance, it is actually only Palu at the moment that brings female lawyers to court as part of its team. So there's a challenge for us there. Having said that, we have a very short time, only 1 hour, to hold this important inaugural discussion. And I was cracking the joke that the organizers were very clever in finding a way of shutting me up by making me moderator. So I can only moderate, not talk. But we do thank our colleagues, the presidency, the registry of the court, the leadership of ELS for this pioneering initiative. We do appreciate that there have been many dialogues, including at the judicial dialogues and other meetings, including of ELS. So in a sense, we have been talking. But the way this has been framed, we really, really applaud these 2 institutions. We were asked to address 3 bullet points. It's not lost that it can be only that: delays and case backlogs, certificates of urgency, ethics and professionalism. But especially in the case management, perhaps it would help if we start by hearing from the court what they have in place now, so that if we are making any inputs on making it better, we're talking from what exists rather than our imaginations. So I'm going to request the acting registrar maybe to make a few remarks, even from there, on what you have now as regards case management philosophies, strategies, technologies, and tools. And then we can open up to a plenary.
Thank you very much, Mr. Donder. So at the ESCJ, in 2017, we invested in a case management system and a case management and court recording system. And we appreciate the role of the former registrar, Mr. Okubo, in ensuring that this is in place. And the system was designed to reduce unnecessary delays and costs, facilitate early and fair settlements, therefore resulting in a quick and just conclusion of case matters. Our rules, particularly Rule 132 and 133, provide for the use of case management and court recording system. Rule 132 specifically provides that the court and parties in every judicial proceedings should, as much as possible, use technology to expedite proceedings and make them more efficient and effective. At the ESC, we have an ICT policy, and that is the policy that guides the digitization of our court. Now, this has not been without challenges. The first challenge is that our court recording system is obsolete. However, the court in the last year managed to procure and install a court recording system in the first instance division. And we'll be able to do the same for the appellate division courtroom once funds are available. In addition to that, there is need for an upgrade to the case management system to enhance scalability and functionality. But most importantly, to ensure that the system meets the performance demands of the court. So as the ESCJ works on improving its systems, we will be engaging funds, and with the delayed disbursement of funds from partner states, this has also held back in terms of digitizing our court systems. Otherwise, the general plan is to have our case management system be able to be utilized even at the partner states by our litigants, particularly in our court sub-registries. And I believe in the next 2 years at the maximum, we'll be able to have a robust system that will ensure that we have, that our processes are not only fast, but they are also effective and efficient. So with that, that is a brief on our system. Maybe I could talk about what the court recording system is made up of. And that is the whole, when you get to court, you have cameras, you've got the audio, we've got the screens that we have, but most importantly, we have the transcribing machine. And with this latest court recording system that we have, we're able to get everything in real time and provide a transcript to the judges, and even where litigants ask, within 24 hours. However, what is still holding us back is the case management system, and we are still working to ensure that it meets the performance demands of the court. Thank you.
We'll entrust the rapporteurs working with the moderator to ensure that everything is captured and put under themes. But time being short, we just open up. Oh, Dr. Noria, you're looking at me. You can kick us off.
Yes, thank you. And the protocol observed. I speak from the perspective of coming from both private practice in Kampala, but also being part of the a local civil society organization in Uganda, Center for Public Interest Law, which over the past about 4 years has collaborated with the court in terms of capacity training for both judges of the court. I think the inaugural training in 2021 for a number of new judges who had just come onto the court, but also national judges and legal practitioners. We actually have funding which was supposed to do equivalent of this, so we'll probably figure out what we need to do in terms of building further on the bar bench discourse. But what is, I think, important is to look at what is ailing the court, and much of it, I think, is something we'll be looking at later in terms of funding. But also, I think, as the DP registrars pointed out, case management. Maybe we need to even look back at the existing case management tools. I know national courts do that regularly. What do we do when we have not just references, but also applications within the references? So is there a way we can fast track the references? I know the court is still doing much of their retooling in terms of technology. But one of the quick things I could think of, I know each time we want to hear applications, we have to come to Arusha and engage the principal judge on scheduling some of those applications, especially those ones which are urgent. I'm looking at the possibility that most of the partner states now have registries, and some of them are upscale registries now. I think the one in Uganda in the Supreme Court in the new building, I don't know where the one in Tanzania, whether we could not just put this burden strictly on the principal judge to hear especially the emergence, those interim applications, and where we could, since these are going before a single judge, could we involve the entire copy of the judges, even if they have to sit in the registry setup in a partner state and say, for me, I'm going to hear this particular application as a judge of the first instance division from Rwanda or from Uganda, and take the burden away from primarily the principal judge. That would help a number of those applications. If we could spread them out with the technology allowing, this don't need to have people physically in one space, in one place. So let's look at that. And also the other thing is to look at where the applications, as if we can feel that the application doesn't make much sense, and I think that jurisprudence had already come out for interim applications, where the court would say, you have brought an interim application ex parte, why don't you just go and serve the other party and we fix a date for hearing the main application? I think also national courts are doing that, at least I know in Uganda, that instead of hearing an application within an application, why don't you just hear the main application? That sort of cuts out some of this. And then I think also we need to enforce timelines. I think the registry needs to tighten on timelines, because we have those timelines which are in the procedures of 45 days, and because I think we have gotten used to, and I think everybody has gotten comfortable, once you file the reference, 45 days, you have served the Attorney General has not responded. Now you go as the applicant, you spend most of the time trying to get the Attorney General to file, consenting to a late file. Take the time and tell the applicant that we have your matter, the 45 responded, can we proceed to schedule? I think the timelines are very critical. Them enforced, then the Attorney Generals will work up, because there are cases which, even 2 years after they are filed, the Attorney General has not filed a defense. Or where there's a defense, the parties are still struggling to confirm notes or schedule in. And yet, again, usually the applicant is the one who is really keen to have the matter before court for hearing. So he prepares the scheduling notes, but because it's required to be joint, he can't get the Attorney General also to sign off. I'm speaking from experience that we have a number of cases where the Attorney General is saying, oh, we'll look at it, even when we have put a joint scheduling with their arguments in the scheduling notes, but we still can't get them to sign up or to agree. So I think we need to look at those, the issues of timelines, issues of how do we deploy available resources, even though as the court is still an ad hoc judge, can we still tap into the resources that we have? That's just my quick thinking on case management.
Thank you. Your Worship, retired registrar, Okubo.
Thank you very much for those who convened this session. I think we have now a situation where a provider, for once, is coming to listen to what other people he gives services are saying. Maybe the court was underrating themselves, or it was overrating themselves. But now because they are listening, they will really know where the position is, where they stand. So it's good to also look at it from that point of view that we are doing business. What are our customers saying? What in Kenya people say is kusikiza ground. Because otherwise things may be different on the ground. Now having said so, I'm a bit sad on what Honoria said about timelines. That is something I never used to allow. And Nicholas and the group didn't like me for that. You have 45 days. If you don't file, full stop. I simply lock you out. So let us just comply with those timelines. Having said so, in I think 2018 or 19, we had a summit that collapsed. And it collapsed because one head of state was not there. And it collapsed because the rules were saying all heads of states must be there. And the heads of state had the opportunity to amend those rules there so that the rules don't mess them up again. And in fact, President Museveni really complained that these rules are impeding our work. And these are our rules. We should be able to change them. Whether they change or not, that is something else. But why am I saying that is because we have these rules here. Now, the good thing about these rules is that you don't even need the council to amend them. The court themselves sit, they amend, they gazette in the East African Community Gazette, then subsequently gazette the date when they'll come into operations. It is very clear here one thing which is provided that can reduce backlogs and make cases go quickly. Rule 69. In fact, it says the quorum is 3. Except where the matter may be so complex, complicated, we have never had it before, then the principal judge might say, no, this one, I think let us sit 5. And we have seen what type of cases like that, the UTCs, the ZWAs, those are very complex matters. And that means if you look at the number of judges in the first instance, it is possible to have 2 courts of first instance sitting at the same time. 3 on one side presided over the principal judge, 3 on the other side presided over by the deputy principal judge. And they all run concurrently. Coupled with that also, sometimes when a reference is filed and you look at it, you will definitely even know the outcome straight away. Maybe somebody has filed the reference out of the 60 days. The court has issued a lot of rulings on the 60 days. It doesn't matter whether you sit 5 or 3. It will not change the ruling. So why not sit 3? And again, on the same, the rules provide for matters that can be heard by a single judge. The court needs to revisit that section and expand it. Where, for example, you have such an application or such a case where it is very, very clear it is filed out of time. And then there's an application to extend that time, which you know it is impossible. Surely one judge can do that. It will save the time of the other judges and create time for the judges to do other things. And again, remember the rules also allow that the registrar can read a judgment once the judges have agreed and have signed it. So do you really need to get 5 judges to sit to read a judgment? Why can't they spend that time to do a hearing, a substantive hearing, instead of just sitting there 5 judges reading a ruling. I used to do that on several occasions. I was given that mandate and I did it. In fact, there's a time, myself and Bonnie, we convinced the principal judge to sit in the afternoon. Why? Because there was like 4 rulings that were ready, 4 judgments were ready, and the principal judge wanted them to be put in the next session. And we were saying this is not fair. We have concluded the matter. It is just a ruling. Why do you sit in the afternoon and deliver it? And the court did that, and it saved that cost time. So let us use these rules to reduce the turnaround time of cases. And I'll urge the court again to review these rules to make it more user-friendly, to reduce the turnaround time of cases. Thank you.
Thank you very much. I see many counsel now have energy to speak. So maybe we hear from you, my lord, and then we go back to the round of counsel on that corner of the room. The Honorable Justice Wejuli.
Thank you so much. I probably should have waited until the bar to first be said and then we. But anyhow, it's a melting pot, so it doesn't matter the order of
Yes.
presentations, I believe.
Yes.
I was just reflecting on what was said the whole morning, right from the CEO of the ELS to the registrar to the president of ELS, president of the court, and quite clearly, one thing ran through. Of course, the issue of the roads is a very key one. One of the ways that one of the impediments to expediting resolution of matters is really the curtailments that are embedded in the roads. So we ask the question, what is the cause of backlog? Of course, there are many, but there are procedural impediments that are found in the roads, which is basically like His Lordship Okubo says, is probably an in-house problem. But then at a forum like this one, it's perhaps an opportunity for us to say, see, the rules are made for the court and the court users. So to get rules that work, there must be input, because the initial rules, I think, were mainly made by the court. But then, given the challenges and the learnings that have been taken over time, it probably might be an opportunity that is raising up, say, we must probably possibly be looking at a bar bench input into rules. So you think of a bar bench committee, rules committee that is getting ideas from the, and especially given that we are coming from different jurisdictions. So if the rules are made by common law practicing judges, then you're going to have a challenge in the civil law. So it's a big opportunity for us to have that kind of discourse. But the other issue that ran through that I think also is a big problem from the cost perspective that is a contributor to backlog is the quality of submissions that comes through. And this was raised by the president of the law societies and the CEO and the president of the court, I think. The quality of submissions that come through impact on the quality, on the speed of processing matters. And the quality of submissions is not because there is a lack of, it's not an issue of competence, but it might be an issue of our backgrounds. If a civil lawyer who is French speaking is writing submissions for a common law driven guest court that's English speaking, obviously we're going to have a challenge. When I was preparing for this, I was just flipping through the case of Uhoji. Yeah? One of the things that led to the delay of that case, it took about 18 months or so, was because of the back and forth of clarifications. So where the quality of submissions is compromised, or is wanting, I should say compromise, is wanting, you're going to have a problem with, first of all, the judges are going to spend a lot more time. Sometimes we translate, you go to different spaces to understand what a French-speaking advocate has very well meaningly put, but actually actually, it might relay a different message if you give it a literary interpretation. So you've got to pay it to fully understand what this French-speaking lawyer is trying to put across. You know, and that takes time. You have to go to a French-speaking colleague, or you go into, you know, these gadgets and say, what does this mean? And that goes even to the laws. Some laws are written in French, so you have to go to. So I think that there is an opportunity for us to address this mission as well. And let me not pose the problem without suggesting a solution. Should we not be thinking of enhancing awareness through the trainings that have been done? I think it was ENS has done trainings, but also embedding ESCJ jurisprudence or laws or treaty as it is into CLE programs for across organizations, so that we know that the lawyers are doing mandatory ESCJ CLE. Then in that way, you know, we have some one step towards the 1,000 kilometer high.
Thank you very much, my lord. Just to assure you, as the mic goes to that corner, that as somebody who has been at the court for long, I do know that every time the court has considered revising its rules, it actually has sought input from its stakeholders. So we've always been consulted. So maybe the value add is this kind of interactive debate brings out more, but the court has always consulted us. One other thing you've raised, my lord, is when we're dealing with colleagues who come from a civil law system. And I've had this discussion with my deputy, the director of programs at PALU, Francois Godbout, who's a lawyer from Quebec, on human and people's rights. And I think the quality of legal interpretation is also a big issue. Many times our colleagues have given very sublime submissions, completely sublime submissions, but it is lost in interpretation. And if I didn't have this friend that we've worked with for 17 years, we'd never have known. So I think part of what we need to do as a legal and judicial sector is see what investments we need to do to improve the interpretation and the translations that we get. Having said that, I think the mic is on that table. There's Evans Ogada, there was Onesmo Olengurumwa, a couple of hands were up. I see you, Mr. President, so let's do those three on that table. Try to keep them a bit shorter. Sorry, I didn't see that you had the mic already, but anyway, finish on that table and move straight to Mr. Roth, the President of the South Sudan Bar.
Thank you, Don. I'll be precise. My recommendations for consideration should be, number one, we should have a dedicated chamber or panel for urgent applications. That will be one. Then number two, we need to define a specific criteria of what constitutes an urgent application and what are the elements of such an application. Because for me, who is a student in the international law, I always get amazed when we are still citing Giela Kasman at the international, at an international court, such as the East African Court of Justice. It doesn't make sense. Giela Kasman is a civil law criteria. What happens to the number of cases that are usually public law in nature? Will we still use Giela Kasman and the criteria in Giela Kasman to look at public law questions? That's a problem for me. We need to also allow for simplified procedures for urgent applications, such as reduction in documentation, or to ensure that we do electronic submissions. We need to think of that. We need to ensure that the registry is available or designated officials are available around the clock to receive and process urgent applications. What else do we need to do? We need to maintain a roster, for example, of judges who can be called upon on short notice to handle urgent applications. We need to take advantage of electronic facilities whereby once, for example, an applicant files, we can be informed that this has been placed before judge so-and-so, and the timelines, the turnaround for deciding that application be strict. 24 hours or 48. We need to do that. Training to judges, registry staff, legal practitioners on how to handle urgent application, that also needs to be considered. I have a lot of points, but for purposes of time, I'll limit it to that. Thank you.
Thank you. Hold on to Onesmo.
Thank you. Again, protocol of ZEB, just to put much emphasis on the bar bench forum. I think this forum, I don't know whether it is entrenched within our legal instruments, because this is where now maybe some of these challenges we're discussing here could have been provided a better room or forum for discussion. So let's take it forward and look the best way, whether our rules and other legal document within the ESG need to adapt this forum to be a formal sort of forum to bring together a bench of our lords and all the lawyers across the East Africa, especially those who, because we are some of us here, we needed to hear from all the practitioners and lawyers who are practicing across the court and also at the national bars. So my call to this official meeting today, let's take this as a very serious and very important sort of an initiative that need to be formalized within our EACJ, and of course some of us need also to take back to our national bars and create again the bar bench sort of forum within our national jurisdiction, so that we can create this sort of practice where members of the bench and bars are meeting and discuss those challenges confronting us in court corridors and even outside the court corridors. That's one. And secondly, human rights cases. Imagine you are filing a case. There's a case, some of the cases we're filing, from 2020, 2019, today, they have not, actually we are getting a rescheduling conference, maybe this month or last month, or others are still pending. Talking about the timelines between the parties, we also need to talk about the limitations that should be given to the court. If we file a case today, maybe a human rights case, a rule of law case, for how long will that case take long? You know, we have some of the cases that are taking in our national courts, 10 years. I've not, no assignment of judges. The same practice also seems to be going around the regional courts. Now from 20 to 25, now that's 5 years already. I just think there, you know, those cases. We still have them. And when you try to inquire, no law, no money for sitting, no whatever. Now, what kind of justice is this? Of course, I'm a human rights lawyer, and I really strive for this, to see that our bench, our judges, both regional and national, give priority to human rights cases. Human rights cases need not wait. We need to address them and urgent sort of intervention so that people can get their rights. This is what I want to bring into this, and I actually appreciate this sort of initiative of bringing together the bench and the bar. Thank you.
Thank you. As the mic goes to Dr. Ruangisa, let me just throw a question to all of us as East Africans, not just as lawyers or judges and so on. Part and only part of the problem is funding. It is when our partner states remit resources to the center so that work can be done. I will have you know that the staff, all the staff of the committee are salary-less right now. So leave alone money for operations. The Secretary General had to, we know because we have a ways of knowing, had to call a meeting of all her staff early last week and tell them you will go without salaries. So that part of the problem emanates from our partner states. Unfortunately, lawyers generally are not well organized to talk about finances, national finances, to deal with the national budgeting cycle and so on. So what do we do? What kind of partnerships will we, especially at the national level, need to evolve in order to be able to better understand our national financial procedures and be able to make the kind of interventions required to make sure money is sent on time? I think we can deepen to that level beyond just saying that there's a problem sending money to Arusha. But to answer another question that you asked, and again to challenge us more, and to give credit where it is due, the East African Court of Justice was the first international court to go virtual in 2020. We tracked the entire world. It was the very first court to go virtual and to go full virtual, where we're doing hearings, including examining, cross-examining, and re-examining witnesses. And before it rolled out the system, it actually called all its stakeholders and gave us the draft rules and the draft strategy, and we made input. So it was quite effective. Again, I did some Google AI yesterday, and EACJ, again, is the first court to consider, first international court to consider a permanent bar bench forum. I've checked at the ICJ, I've checked at ICC, I've checked at the European Continental Courts. Nobody has what we are proposing now. So again, I think we give you, my lords, my ladies, our congratulations and our acknowledgement that you actually are trying. So the question is, how do we build on that? Dr. Rwangisa.
Thank you, Don Dare, my good friend, with whom we struggled to get the court stand on its own at its infancy. If we don't resolve this issue of having permanent sitting of judges in Arusha, we will keep on lamenting. This is going to be our perennial complaint that this is a problem. We are talking of matters to come under certificate of urgency, should be given the attention that they deserve. By whom? When the judges are not in Arusha. Presently, we have president and principal judge who are in Arusha, at least on permanent basis. The only thing you can say and ask the court to do is to regulate and adjust the rules of procedure to make sure that within the means that existing, the court can at least, or if possible, use the existing judges who are permanently resident in Arusha, at least to handle matters like of applications or any issue coming under certificate of urgency. But if we are to call these judges to come from where they are, at any given time, there is no urgency at all. That is the problem. The structure itself is causing the problem. But we can't keep on complaining and lying our back sitting without taking an action. I remember when I was the registrar, by the way, I need to correct Madam Deputy Registrar, Acting Registrar here, the case management system and the court recording systems were not launched in 2017. We established these procedures, these applications in 2012, and they were launched by the summit in Simba Hall. I remember engineering this. And many judiciaries in East Africa have learned a lot from the existing case management of the East African Court of Justice, as well as the court recording. Actually, we are talking of AI. People are talking of AI today. East African Court of Justice was in East Africa the first to use AI recording system. Those microphones you see are AI oriented. The nearest you are, that is the one that picks on you. It also picks your image. It gets displayed. That is artificial intelligence kind of microphone, instead of holding you seated there. So I'm happy that the case management system has helped. It has no problem. Let's talk about the other things. There is no problem with the case management system or case recording system, because the simultaneous, in less than 30 minutes, a judge has the proceedings of a matter that has been heard. So we can only make sure that it facilitates. Things like submissions can be done online. As we do, we find the best way of improving our way of doing these matters. But case backlog has never been a cause. But we see we are being assisted by case management. But the judges, should now look at the rules, which are not cast on stones. They are within the full competence of the court. To see on regular basis they are being tested, let us make them updated, up to date, as his worship Kubo there said. It is within the competence of the court. To having tested them, please look at where there are failures. But as you test them, make sure you consult the stakeholders. I remember sending copies of the first draft of the rules of procedure to the bar associations of the region.
Yeah.
None of them responded. None of the regional bars associations responded to the draft rules of procedure. Let's also look at ourselves. How much are we contributing to this? How much are we supporting the effort? I get another opportunity. Let the others also speak.
Thank you, Prof. President Arop is next to me. And we also encourage our colleagues, even those who may not necessarily practice currently at the East African Court of Justice, but have best practices or ideas from other courts, whether national courts or other international courts, feel free to also just input into that. Yes, Herbert, after Arop here.
Thank you, moderator, for the chance. My remark will be in context as one of the youngest members of the bloc, also one of the youngest bar association. First of all, there is a fact that I feel that everybody should know. As many of us know that as a young member of East Africa community, there were a requirement of sensitization about the treaty itself, the institution of the bloc. This fact in South Sudan, I believe it was not done. We have the great majority of people are ignorant about the treaty itself, about the institutions. Coming to make my remark in the key point, the first point, I'll add one word, accessibility, because based on this. In my national context, first of all, we don't have a sub-registry office in Juba. And as you've been following, we have some cases as new members were taken to the court. And some of them were ruled upon. So now there is a small understanding. And as a national bar, and the majority of the practitioners, the court of procedures and the procedures of law of the cases at the regional court is a challenge. They are not aware of it. As Professor said, as a new bar association, we were not having that privilege to be shared with the draft of the procedures. So accessibility of the East African Court is very important. When we talk about the issues of the case and backlog, any judicial body, the most important thing is independency of that body, the way it is structured. And as I can see, as the acting registrar said, issues of funding. Independency goes even to the fundings of the body itself. Of course, there will be issue of backlog of cases, since the court is not sitting permanently. So as a recommendation, it has to be looked how it can be a permanent seat so that cases can be addressed efficiently and managed. The other point is going to the delay in the cases. As I put it, it goes to that the court is not a permanent court. So also other issues, including this certificate of urgency, Professor has already addressed it, the same point that I wanted to make. So I will stop here and give the chance.
Thank you. My friend Herbert at the back, the table there.
Thank you, Don. protocols observed. Well, I want to start with the one that relates to raising the funds. I want to acknowledge, just like Don acknowledged, the fact that the implementation of all the courts works need to be supported financially. And I think we all do agree to the fact that without the financial support, without the financial muscle, we can't do much. And while Don was talking about that, I actually, realized that the area that we are being told to go to or to approach is somehow a scary area, because I can imagine, how about, putting pressure on the government that you guys, you need to pay up your dues, because without paying your dues, then nothing is going to happen, either at the secretariat or at the judiciary. But anyway, that said, I think it isn't something that we can let go without, giving our try. And one of the things that I'm looking at, maybe that we can suggest, is to look at the ways and means of, let's say, how we can even propose incentives, so that, let's say, those countries that pay up their dues on time and fully, they are incentivized in terms of, let's say, it could even be putting them on record, or something else that can be thought, but at least that way they are recognized for having done their duty. Number two, maybe we always have these regional platforms. And I think in form of either campaigns or awareness, we can use these platforms that we are always engaged in one way or the other way to make sure that, I don't want again to use this heavy word, defaulting countries, but anyways, the countries that are not paying up their dues, they are sort of, encouraged to pay up their dues. So I think the list of strategies is endless, but I think surely there's something that can be done so that our respective, partner states can wake up to the call and pay their dues on time. That said, I think there's something very important that was talked about, which relates to the backlogs. Of course, I want to appreciate and step in the shoes of my colleagues who gave their submissions first. Backlogs, indeed, they sort of, hamper the recognition, but also the feel of the justice that we expect most of the times when we are looking up to the courts. And while I was thinking about that, I also thought about maybe some of the practices that have seemed to be, not perfect, but that have changed, one or two things. Don, you talked about, the introduction of the virtual hearings, something that was appreciated, for the court to have actually taken that route, which we do appreciate. But maybe, and your lordships, I'm not again questioning this. I don't want to risk, tomorrow or the other day, joke of course. But I was thinking, how is that consistency of that virtual hearings ever since it was introduced? Did it die out with the COVID pandemic, or it is something that was sustained? If it did, slow down, let me know, maybe let me withdraw the dying. If it slowed down, can't we, sort of revamp it and have it, again, reactivated so that it can continue happening? Because this is something that has actually proved to be very efficient, especially like here in Rwanda. Number two, again on case backlog. I realized that and by the way, something that I was very much happy about, because of a number of things. But when you look at actually most of the issues that we are dealing with today, especially things that relate to case backlogs, something which is very interesting, you find that most of the things that can be rectified or that can be improved to put things right, they are within the powers and the discretion of the honorable judges. And my thinking is, Now, for example, like the scheduled conferences, we normally call them here in Rwanda, we call them pre-trials. I was wondering if, you know, maybe at some point in future, your lordships, when you come to consideration of the rules, if, you know, some of these things cannot be given or cannot be relegated to the discretion of the clerkships. So that, I mean, like for us here in Rwanda, of course it has its vices and virtues, but it has worked in one way or the other way, whereby the clerks do undertake or carry out these pre-trials, all conference schedules. And of course, also introducing the system of unique judge, I think it is also one worth consideration that can be looked at. Thank you.
Thank you very much, Herbert. I recognize you. Our acting registrar, maybe move the mic there. As you do that, again, I want to throw something into the meeting. We all appreciate that a journey of 1,000 miles starts with a single step, and we can't get everything right in the beginning. I was just looking to see who is not in the room. We don't have representatives from the council, the office of the council, to the community in the room. I think next time we should insist. If they're online, maybe? Okay. We also don't have a lot in the room, the representatives of the state bars, and especially the state bars from the 8 countries. Something we can improve going forward. But also, we don't have our colleagues who are in parliament, members of the East African Legislative Assembly who are lawyers, and especially the committee that deals with legal rules and privilege. So maybe if we ensure in future forums we have them here, then the entire legal profession, the bench, the private bar, the state bar, the legislature, we can all tackle this issue of financing and this issue of resourcing together. Because I think it is one element and only one to say the judges should sit more. That's an element. But a judge does not work on her or his own. He or she needs a team. They need secretaries, they need clerks, they need legal researchers, and so on. So how do we look at this entire infrastructure if we want the system to work? Because otherwise, even if the judges are full-time and we don't work on these other elements, we might still feel pain. Having said that, Honorable Your Worship.
Thank you very much, Don. I just wanted to give a brief background to how we came about the decision to come up with the Bar Bench Forum. And this, I believe, we were looking at the activities of the court, how we can source more funding. And during those conversations, of which Les was involved, we realized that there was not a good understanding, number one, of the challenges of the court, especially by our key stakeholders, who are the litigants. And also, we thought it's important that there is a conversation that is required between the ESCJ and the litigants to see how we can try and resolve our problems. Mostly because the court wholly depends on the partner states for funding. Looking at our budget of about 4.5 million, approximately, US dollars, about 65% of our budget goes to court, to staff emoluments, that is salaries and judges' retainer. About 20-something% goes to court sessions. The rest goes to operations of our court. That is where the challenge is. But the biggest of our challenge is the fact that states are not meeting their obligations. As we speak now, only 4 partner states out of 8 have made their contributions. What does that mean? For the rest of this financial year, we are not sure we'll have salaries, we are not sure we'll have court sessions. And for us, that is where the problem is. And it is important that we have these forums so we can think about how best for the court to meet our mandate but also how the litigants can support the court. We have our court stakeholders who have had a good understanding of our challenges. And I want to particularly commend ALP East Africa, of which Dr. Gloria is a knowledge partner. Now, ALP has taken it upon themselves to mobilize funds. And what are these funds for? What these is to train advocates from our partner states. So far, we have visited every partner state, apart from DRC and Somalia, with the support of ALP to ensure that advocates in the partner states have a good understanding of our rules. Because we believe the quality of submissions is very key in the success of our court. So I commend ALP for that. Now that is the purpose of this bar bench forum, to have more of our partners like ALP coming in to support the court in our functioning. ALP has also supported us in training of judges from the national judiciaries, because you understand how the preliminary rulings provision in the rules of procedure works. So if the court does not have the funds to reach out to these key stakeholders, then we should also be able to have our partners support us to make sure that we deliver justice effectively as we aspire. So I want to appreciate everybody who has been able to come to this inaugural bar bench forum, and I believe by the end of today, we will all be speaking the same language of how can we enhance the functioning of the ESCJ, but how can we also enhance the work that our advocates are doing, especially in our courts. And I think we can also come up with strategies of how best to engage our states, not just engage them, but also hold them accountable for crippling the court. Because that's a very big issue for us. I mean, you can't have at the half of the year the organs and institutions of the community not being able to undertake their mandates. And as he did say, our organs don't have money to pay salaries. At least the February salaries were not made. So I thought it's important we have that information at the back of our minds as we're thinking of the best strategies to adopt to improve the work of our court, but also improve our collaboration as partners. Thank you.
Thank you very much, Your Worship. I see Emily at the back there, and then we'll come to you, Mr. President.
Let me start by appreciating, thank you so much for this opportunity and the forum. For purposes of funding, we have some cases that were filed in the court to hold some states that have not been remitting their dues on time accountable. Is it possible that those matters be fast-tracked? Because then they will help to set a precedent that those ones who don't remit their monies on time, there's a precedent that will be set. In as much as, of course, it will be uncomfortable to some of these partner states, but let it be set so that the organs and the institutions of the community should function seamlessly. That's what, number one. Number two is on certificates of urgency. Indeed, it's a major challenge because most litigants feel that they have filed their certificates of urgency and they're not heard on time. Is it possible the court to set timelines within which to process certificates of urgency, even if it's online, so that litigants can appear online, judges can appear online, and they are processed? I don't think that even if the court is part-time, in as much as we are pushing to have the court full-time in Arusha, still even if the judges are in their partner states, it can still work if they are able to coordinate and we are able to, at least these certificates of urgency should be able to be seen that there's something working. Because when now I go back to my client and I'm telling them, you see, this application has not yet been set down for hearing. They ask now, why is the court not hearing us on time? So is it possible that we try as much as possible as a court to fast track certificates of urgencies, so that where one judge can sit for an application under Rule 69, let it be heard seamlessly and feedback be given, even if it's via email, litigants be given feedback, and if they have to appear, they appear virtually. Lastly, handling of judgments for purpose of case backlog. I'm of the opinion that let the court exhaust use of technology, even emails. Judgments, rulings can be delivered by email so that we free our court's course list for purposes of hearing applications and references. And even scheduling conferences can be had by the deputy registrar. If the rules can allow, the deputy registrar deals with pre-trials, the judges deal with serious matters, which are hearing applications and hearing of the references. That will really help, because I'm foreseeing in a few years to come, the first instance will be choked. And maybe the judges may really not now, because by now in 2025, we have matters of 2020 that are even yet to be heard. Maybe we need to be innovative so that we help the court. Thank you so much.
Thank you very much, Emily. I'd like to take a special moment as the microphone goes to President Tewodros Getachew, President of the Ethiopian Federal Advocates Association, to celebrate Emily. Emily is one of the young female lawyers that brings herself to the court. She does assist PALU, she does assist LSK, but she proactively brought herself to the court with her colleagues and have done a number of cases that have been very, very useful for us. Apart from that, the only other women lawyers that you will see in court are the pan-women lawyers. We have little money, so they couldn't be here in person. But you'll find Esther Mwigai Mnaro, you'll find Praise God Joseph, you'll find Nema Jaji, you'll find June Cynthia Okello. Those are the young women leading lights that are pushing the court to the next level, and we celebrate them. President Tewodros, who is also Vice President of PALU for Eastern Africa. So I'm also being monitored and observed in terms of how I'm doing my work. Welcome, President Tewodros.
Thank you, Mr. Moderator, and I'll see you. I stand with the protocols that are already established. Good morning to everyone, and I'm delighted to be here. And of course, we have taken a bold move to bring the Ethiopian Federal Bar to the East African Law Society. As you know, Ethiopia is not a member of the East African community, and we are here to learn and as well to contribute. I'm just making a few comments as an outsider, since we never engaged with the East African Court of Justice. I have been working as an international legal advisor with a couple of international courts, such as COMESA Court of Justice, and have attended many of their retreats, and were able to give some trainings for the justices in some of the international courts. So I'm just going to comment on what I usually tell for those regional and international courts. So there are some basic issues that, whenever we discuss about courts, there's always an issue of legitimacy, whether it's normative or descriptive. I leave that for the members, especially for the 7 member countries of the East African Court of Justice. But when it comes to regional courts, one of the major issues that I see is visibility and awareness. So with that, I guess the East African Court of Justice looks like working very good, because we're talking about a number of cases here, as I can see, and I have been following the East African Court of Justice, even though we are an outsider. I have been following your activities, and it's very good. So it's something to add up on. Probably the other issue is the decisions, these regional courts make themselves relevant by themselves, by their own. Their fate is in the hands of these honorable judges that we have here with us today. The quality decisions, that's what attracts litigants, lawyers, bar associations to engage with the court. So the quality of the decisions they deliver, not only the quality, but also the execution, whether the courts can give a decision and a ruling that can actually adhere to. We have to make sure that those courts are giving decision to be executed. It's not something like a proposal, it's a court decision. So I'm not sure how the ASCG have been doing in this aspect, but from my readings, you are also performing good in this aspect. And the other issue, probably a very important issue, I'm raising this issue as a bar president as well. It seems like that the East African Court of Justice has an advantage of mobilizing its constituencies, including the regional bars, like the ELAs. This is a very important issue. One thing that, for example, if we take COMESA Court of Justice as an example, that's one thing they lack. They don't have a regional bar who they use to mobilize the legal community with themselves. So some of the courts, they might end up to be a labor court at the end of the day. They might, might not achieve what the bigger picture that they have been organized in the first place. So regional integration is, as I can see, the bigger picture here. So you are very lucky to have a vibrant regional law society like the East African Law Society. So you have to take advantage of this very important and strong structure. The last issue that I want to make is regarding your interpretation policy. Honestly speaking, I'm still commenting as an outsider. I don't know what I don't have such deep understanding how the ASCG is working toward this, interpretation. So what I can say is one of the disadvantages that the regional courts lack is if they follow restrictive interpretation policy, that's where lawyers lack interest. That's where bar associations, law societies lack interest to bring their issues to the courts. So this restrictive interpretation, the courts should come up with some kind of, the other way around, not restrictive way of interpretation. So this is one of the issues that the courts lack. And I don't want to take much time than this. Thank you very much.
Thank you very much, President Tewodros Getachew. As I said, President of the Ethiopian Federal Advocates Association and Vice President for Eastern Africa of PALU. I'm bringing the session to a close. I think the issues will continue in the next session. But just to endorse fully what you've said, President Tewodros, around how a court, especially a young international court, chooses to interpret its jurisdiction, its mandate. And it is true, from the COMESA court, the restrictive manner in which they chose to interpret their mandate is how they do not have work. Vis-a-vis how this court, for instance, in its history, and despite the challenging time of being a very young court in an area that was still in early stages of democratization, how it chose to weave with the wisdom of Solomon around its inaugural cases, Mwatela, Nyongo, Katabazi, the first ELS case, is why we're still here and why we are still optimistic for the future of the court. So at least I give you that. Also, I really like the challenge that has come both from the acting registrar but also from a number of suggestions like from Emily Osiemo around how can we be dynamic in how we visualize resourcing this court. Because resourcing is not just cash, and cash does not have to come only from the partner states. Clearly, for those of us who are active litigators, because we also need to separate litigants from litigators, we are conflating the two. Sometimes litigants are also the litigators, but sometimes we're separate. For those of us who are active litigators at the court, there's probably some certain kinds of support that ethically or in terms of perception we should not engage in. But a court has partners, including partners who don't litigate before it, such as our colleagues who have financed us to be at the Raoul Wallenberg Institute. So if we begin looking broadly at the stakeholding of the court, what kinds of needs of the court can be met by other partners? We do know, for instance, for the African human rights system at the continental level, our colleagues from the Center for Human Rights at the Faculty of Law at the University of Pretoria does second master's and PhD students to the African Court, to the African Commission, and so on. So they do part of the research that needs to be done. So can we think creative about that? How do we get researchers to the court? What kinds of technologies can well-wishers of the court be able to provide? Apart from the sessions of the court, like we've had our colleagues from ALP have been able to provide for the court the ability to go around the continent to meet its stakeholders. So maybe we think creatively around resources, human, technical, and financial. And then rules. I think kicked off by the Honorable Mr. Justice Wejuli, there's already this move that we need to revise the rules in light of what is our lived experience, and a couple of practical suggestions have been given, Rule 69 on quorum, possibility of simplified, expedited procedures, and so on, single judges to be able to handle as many matters as possible, certainly the pretrial matters, the interlocutory matters. There was that interesting suggestion that even this bar bench committee, maybe we create it by the rules of the court. So I think a lot has been put to kick us off. I think we have got good energy. Please let me hand over back to my brother David Sigano, the CEO of ELS and the acting registrar, to transition us to the next session. And don't necessarily impose on those people the obligation to stand throughout. We come from a place of a lot of strength. Help people stay healthy. Thank you.
Thank you, Don. I think that was a really well done moderation. Can we give a bigger clap to Senior Don there? We have taken in, at least I have written a lot of notes on the recommendations that have come from both the bench and the bar. We are going to reduce this into something more comprehensible and something that can be utilized to make the court better and to, of course, improve the relationship between the bar and the bench. We are going into our next session, and this is a very important one. The contributions of the bar and the bench to procedural and jurisprudential developments of our very important court. I have to say, since the court started operating in 2001, I understand the first case really came in 2005, the Andrew Calist Mwatela case. And the court, as formatted, was supposed to resolve mostly trade-related issues. However, after 2005, there was more of a shift because more litigants were willing to bring human rights-related cases compared to trade-related cases. Actually, it's just recently that we have had a lot of trade-related cases being brought before the court. And it's because of the courage of the judges in terms of the decisions that you have made recently. If you look at the BAT case, if you look at the Kyo case, very recent decisions that have had tremendous impact on the willingness of East Africans to bring cases before you. And so as we look at this jurisprudential growth, allow me to call to this podium the people that were there at the time the court really kicked off its operations. And by these people, I refer to Professor Ruhangisa, who was one of our very first registrars of that court, as well as our rule of law chairperson, Mr. Evans Ogada. I believe you do not need any introduction. Kindly. Can we clap for them as they come?
Well, thank you, David, for the introduction. We are going to co-moderate this session, myself and Evans, in a manner that could probably save on time because time is of essence. We decided to formulate questions which would guide us for those who are capturing the records can ably put something in place while we make sure that we confine ourselves within 1 hour. And please keep us sending a warning for that matter. Well, this is very, very interesting. The topic itself is very interesting because it touches the foundation, the substance of the court, the work done by the court. Is it of quality? If not, or yes, why? Would be the next question. If it is not of quality, why? What are the factors that might have contributed to that lack of quality? If yes, then we give a thumb to the court. But there is always improvement, room for improvement. And we keep going to church and mosques to salute God. Why? Sometimes you don't go there to get anything new. You get things which are being recycled, but since human being is under constant, has to be on constant review, you go there at least to get your mind struck and get reminded that this should be how it was. This is the situation. We are looking at the quality of judgments is a result of quality submissions, quality references. Once you feed a computer, for example, you feed it with the junk, then what do you expect? If pleadings are poorly done, you shouldn't expect also the best of the judgment. The best the court can do is just to dismiss the matter and take you back to the drawing board to bring something proper. So references also have to come in quality form. Judgments will depend on the quality. Judgment depends on a number of things, including the amount of research being done. Is the court capable of doing such research, big research? How many research assistants does the court have on those areas? Presently, the court has only one research assistant, isn't it? She has retired. Now, you see, there is no research assistant. Now, we expect a quality judgment for court that is not even full-time. Those are the things that we needed to look at, because I remember when I was the first registrar, in the first case, I was the one doing research for the court. And sometimes assisting the judges to draft the judgment, give them to see it in deliberations, at least they have a working document. Later, I proposed that we get at least research assistants to assist the judges, do the nitty-gritties here and there. Now, she has retired since and not replaced. We expect miracles. I keep telling people that East African Court of Justice, in terms of staff, it qualifies to get into the Guinness Book of Records for being called a court with a staff complement of 15 people. Is that a court? We need to reflect on this. So let's look at these questions. And I would like people to answer them. My colleague will also come to join to help me at another stage. I will call him coming. How can the quality of references and judgments in submissions to the EACJ be improved, assuming the quality of judgments are not impressive? How can they be improved? We go for solutions. We cannot be perennial complainants here. Let us propose, in case the status, the quality of judgments is not, or judgments is not impressive. How can it be improved? Yes, Your Worship. This is how our time is being consumed.
Thank you. I think if you look at the workload, we go back to research assistants. Fine, we had one who was now gone, and they have none. At some point, Raoul Wallenberg used to fund us a research assistant, which went on for about 1 year, and they stopped that funding. But before you blame judges for that, I think they need support. And that support should come from research assistants who are lawyers. It goes back again to the structure of the court. Can it be that any time an additional judge comes, that judge comes with a research assistant? Thank you.
So the proposal that at least every judge should have a research assistant, that's very true, because my experience, when I was writing my PhD thesis, it was on a tone of kind of radical. It was radical. At one time, my supervisor asked me whether I intend to go back to Tanzania after completing my studies. And I said yes, but I wanted to know more. Why was he asking me that? So I said the tone on which it is written was too radical. And why? In one paragraph, I pointed out that partly judges, particularly of the Court of Appeal, were harboring ignorance. Some of the judgments reflected ignorance, and that ignorance was a result of not doing research. Not that they wanted, they did not have time. Where one judge of the Court of Appeal attacked a judge of the High Court for giving subheadings, to a judgment that did not qualify to be a judgment. It only qualified for academic. But I said, no, this is ignorance, because when I read the judgments of the Supreme Court of the Caribbean, every paragraph, every issue has a subheading. When I read the judgments of the Constitutional Court of South Africa, had similar subheadings. Reading the law reports of the Commonwealth, judgments had subheadings. What is that if not ignorance? On the part of the judges of the Court of Appeal, the highest court in the land. I recommended every judge should have a research assistant. For those who don't know the Tanzanian research assistants, where did it originate from? It originated from my PhD thesis, which I submitted to the then Chief Justice Nyarari. He took action.
Thank you very much. I'll start with what you have just said, Professor, in terms of research assistants. Now, I assume that majority of the judges that we have are also judges of the courts in their respective jurisdictions. And probably they have the resources, and I don't know, now I'll be biased because I do not know from other jurisdictions whether they have. So maybe I'll withdraw that. But from Tanzania, I know that judges have judges assistants. So if we were to empower these judge assistants who are coming from the jurisdictions to understand the intricacies of EACJ, that could also could help. But then I was thinking, I and Emily come from TGCL. We have a group, a larger group of students from Tanzania, German assistants who are doing master's degree in East African community. And some of us who have done it have not practiced. Can the court think of an MOU with the TGCL temporarily or on an occasional basis through the alumni network that is there, to use those students who were trained and not have the platform to practice EACJ law or EAC law and assist the EAC as part of temporary research assistance when certain matters need intervention. I think that is something which we as students or former students will love to test and assist, and maybe only secure recognition that we assisted the court in some way or another.
Thank you.
Thank you.
Yes, I will move to another question. My Lord, I want you to come back later. Oh, you want to respond to this particular question? Briefly, yeah. Can you pass a microphone to him?
Thank you. Of course, I realize perhaps would have preferred all the judges speak last, but it doesn't help because we are not in a, I think we're in a discourse of. So I think, like I mentioned earlier, this is a bifurcated problem. It's an issue. It's the quality of judgment and the quality of the case. And indeed, my belief still is that a good judgment stems from good pleadings, everything else being constant. I mean, the judges and the bar are competent and all that. The quality of the pleadings, the quality of the submissions, and of course there are other procedural things. So if the quality of the pleadings is wanting, there's a lot of difficulty in, first of all, for the judge understanding the case. If the submissions then come in and they're wanting, it even makes it harder. If you look at the cases that have been before this court, you'll ask, why was Katabazi decided the way it was, and why was Sitenda Sebalu decided the way it was? Was it not, perhaps there was a misapprehension of the matters before this court, the jurisdiction of the court? So if the bar, the litigant, I think they mentioned the litigant and litigator. If the litigator comprehends the treaty and knows that the court has this mandate, or my client's case fits within the parameters that are laid down by the treaty, then you're going to have a problem that sometimes arises of having an otherwise justifiable matter to hear thrown out on technicality. Sometimes, as a judge, you look at a matter and say, why did this litigator not advise this litigant? How can this person be coming to court 6 years down the road, really a litigator, like they are mentioned, who knows the rules of this court? You'll ask the matter she raised, I mean, we are all lawyers first. We are all members of the bar before we become, bench. The issue of practice across the region, and the matter comes before you, and you have to throw it out on technicality without going to the merits. And yet we know that as the bar, one of the most painful parts, pressure points, is the inability to practice across, But as a judge sitting there, I know that this matter cannot pass the basic, it falls out. Without mentioning specifics, last week here, we had a case, which was supposed to be a representative suit, Thousands of peasants. We had a full courtroom of peasants. I'm sorry to use that word. It's not derogatory, but that's what it was really, These fellas had to be, their matter had to be, and give, appreciate the litigator for the humility they had. But you can imagine these litigants who invested their hope in this matter and thrown out on a technicality because the litigator did not advise the litigant on the, So the quality of the pleadings, the knowledge of the treaty will inform the decision. Sometimes the decision will be a hard one, but a right one based on the technicalities. Sometimes you'll make a decision that you, even as a judge reading it, you know that I am bordering on, I'm sitting on the fence perhaps, because of what was put before me. Sometimes you ask lawyers in court, and they will tell you that we stand to be guided by court. Now surely, is the court going to guide you on whether or not this matter that is completely filed out of time should be dismissed? And you are the respondent, and you are telling court that we stand to be guided. So you end up making the bench descend into the, and it's painful. So I think this is a good forum for us to come clean and talk to each other in this way.
Absolutely.
Thank you.
There is a share on the part of those who present the cases, and also a share, as I started in my introduction, If you feed even a computer, in this case, I don't want to say my ESJ is like a computer. I mean, you bring, you know, rubbish, you can't expect quality. It will be dismissed in its entirety at an early stage. Time is not it's not on our side, and I'm trying to make sure I don't offend the registrar. I will come to you later, my lord, as we go around. So the question that my lord has answered is that there are roles, partly from the bar and partly possibly from the bench. Each one has to look at its side. How does it how is it done? John there, Seka, proposed some improvement in our curricula at the universities. So you get students who are familiar, or future lawyers, advocates who are familiar with the application of international law in international courts. There you can speak the same language. And problems like the one raised by my lord here wouldn't probably arise. I will ask you another question. What strategies, now that we have read the judgments of the East African Court of Justice, we have seen the quality. What strategies can be implemented to strengthen especially the reasoning and the legal arguments which are presented to the court? In very simple terms, tell us the strategies that can be done. In simple terms, we are pragmatic. We look for solutions. If judgments are wanting, what is it that can be done as a strategy to improve them, as well as even the submissions? Yes. Don, can you? I took it upon myself to pick on you because I didn't see any hand. I thought, yes, would you like to say something?
Thank you very much, Prof. I think the points have already been made. One, about how we resource the court in its entirety, especially research and drafting assistance, and the partnerships that can be structured, including the one suggested by John Seka. I think the point has also been made about how we, from the bar, both the state bar and the private bar, improve on our own drafting and on our own submissions, written and oral. I think there's a question of ethics there raised, especially when you talk from the position of the bar. I think Justice Wejuli has brought out that point. How do you come to court to tell the court that I stand guided by the court? What were your instructions and what was your preparation? And another thing, again, you said that our state bar colleagues are mostly online, not here. If a point, especially the questions on jurisdiction, this court, and I know for a fact also the African court, have been very elaborate in circumscribing what is a jurisdiction they believe they have, and they have repeated it over and over and over in the jurisprudence. Is it ethical for counsel to then come and build an entire case around denying jurisdiction that exists, and therefore we waste limited judicial time relitigating a matter that has been completely settled? And at what point does the bench then begin sanctioning the counsel for wasting precious judicial time? At what point do we go into sanctions? We used to have a bit of that with one of my most favorite presiding officers, the Honorable Lady Justice Monica Kalyagira Mugenyi. She brooked very little nonsense, if I were to use that word, in her court. Same, if you go to the African court, about 10 years ago, we had Justice Sophia Benabuafoa Akufo, who again, the gavel was always here. So we as counsel before the court had to be very precise in what we're saying. So I think there's a question there both for the bench and the bar that we could do better. And I think there's a role also in terms of this issue of jurisprudence for the academic institutions. I do not subscribe to the school of thought of my learned senior and former teacher, Ahmed Nasir Abdullahi, or my colleague Nelson Harvey, who will critique judgments and judges very flippantly without substantiation on social media. It's their right, freedom of expression. But we do have a role for our academic institutions to critique the judgments very constructively, and in so doing, be another arm in holding our judiciaries accountable in terms of questions of quality. Right now, as far as I know, it's only Kabarak law that does that in a very consistent manner. Again, my friend Emily and our other colleagues at Kabarak. But maybe that's an element that we should also be intentional about, that we have journals where if we have opinions, we make very well-reasoned and argued opinions, rather than this flippant misuse of social media by officers of the court. Thanks.
Thank you. Now that we have platforms like this one, we don't expect any lawyer, counselor, what's the name, going out in the media to critique the judgment of the court. When we have platforms like this one, these are the fora where if you have a misgiving, you a certain feelings, come and say it openly, you will get the benefit of hearing from the judges. Who would ever knew that judges are facing a major problem of even understanding the pleadings? Yet we expect them to come out with the best judgments. That on our side, we don't spend enough time to prepare ourselves, to present to the court a quality submissions for the court to be able to come out with a quality judgment. Now, my time is so limited. I want to propose rather to introduce this kind of by way of provocation. I want to provoke you. My Lord, we are here to look at and talk to each other candidly. And everybody has been candid in his or her presentations. I wanted to find out from you, without necessarily telling me before I go ahead, how do you feel? How free are you to sit in a matter that involves a partner state that you come from? Because this has been a complaint outside there in the streets. How do you feel? Is it a case of saving your own skin? Hey, you also have a skin to save. Because at the end of the day, after the session, you will go back home to sit and engage, meet these people who may even ask you and brand you as a non-partisan for deciding against your own country. Because in East African Court of Justice, who are the main parties? Partner states, Secretary General. Now, how do you feel? That is a big question, which introduces me to an idea, which I call provocative idea. How do you feel a proposal that a case involving a country, a partner state where a judge comes from, he should not take part? Also, to be safe, and this is not hypothetical, I will give you an example. I remember in Yanyanganyong, judges were smacked and they accused of not being partisan, of not being patriotic for deciding the way they did. Why don't you think of even saving your own skin by stepping aside and let others decide? This is in the spirit of building, coming out with the quality judgments. The African Court on Human and People's Rights does it. You are also human beings. I remember the judges at that particular time were fought on their face, attacked for deciding or performing their own duties. In order not to risk, can't that be compromised? Candidly, that's a question I'm trying to ask. If it is possible, why then don't you go ahead to amend the rules of procedure? The judges in Kenya were accused of not being patriotic.
by deciding the way they decided in Anyanganyong. And it was said in the face, it led to the amendment of Article 26C of the treaty regarding the disciplinary measure, removal of judges from office. Which judge here would like to be removed from office? As a matter of fact. And it was done within a short time. What Don called surreptitious measures were taken within a short time. The treaty was amended to include all other possible reasons instead of those which are commonly known in country judge compromise. That is my proposal, that to be on the safe side, just step aside and let the others do it. You are not reinventing the wheel. And that will be my last involvement before I invite my colleague to continue with the others. My Lord would like to say something before I come to you, my brother. Yes.
Thank you so much, Professor.
Oh. Huh? Yes,
yeah,
go on.
Yeah,
I
imagine
didn't see Professor Sempembo's hand. He rose it in a manner as if he was saluting. Yes, my
the way you are framing the question is like you actually expect the responses from the judges themselves. And
no, this is for you to sit at your own because
no, and we are very happy to respond. That's what I'm saying.
Okay.
I think all of us take an oath to be true to the treaty. I have no illusion that none of us considers ourselves as sitting here on behalf of our partner states. By the way, back at home, those of us who serve in the benches, we are used to this. So it's really not a big deal. I would imagine that actually we would not be improving the quality of our judgments by asking judges not to sit merely because a matter comes from their own country. Judges, by virtue of their oaths, should be able to make a decision irrespective of where that case comes from. So for me, I would really not worry much about that. We've taken oaths and we'll do the best. When a matter comes before the court and it's from Kenya, if I think it's contrary to the treaty, I cannot have a sleepless night because I think it is contrary to the treaty. It's the same thing I would do at home. Yeah. So I think we'll be making a big mistake to say that people should not sit because their countries are involved. When we sit down and conference, you are surprised by the kind of ideas that come from across all the partner states. And I think we would be denying the quality of those judgments if we were to say some of our colleagues should not sit because the case has originated from home. And by the way, the moment we actually take that proposal, we are telling the partner states to continue harassing the judges. Thank you.
Thank you. Professor Sempebwa, and then I will come to my Lord Chebo.
Thank you very much. Thank you very much. Am I heard?
Yes, we can hear you.
Okay. Well, I agree with the previous speaker that judges in their national jurisdictions are always adjudicating matters involving the state. So I don't see any problem with that. But that was not my reason for standing. I was dying to contribute on the next bulletin, which is enhancing accessibility to the court, but I don't know whether I'm out of order.
You could be out of order
that
it was to be
within the jurisdiction of the next
of Evans,
moderator.
Yes.
Okay, I'll
but
hold
now
on.
that you have the microphone, go ahead.
All right. This is a matter which is quite important. The way we have reached, it has been mentioned before in this forum, but I would like to emphasize that the training that has been given should be more intensified to make it clear to our national judges as well as practitioners that they have an important role to play in enhancing the community law. First of all, national courts are empowered to implement community law. They don't have powers to interpret community instruments, but they implement community law. In the first instance of implementation is direct, where protocols like the Common Market Protocol gives them power to enforce the economic rights under that protocol. And these do not have to go to the East African Court of Justice. And if they go there, the community, the Court of Justice should assist in enabling access to it by returning these matters to the national courts and saying this is a matter that can be litigated at the national level. And if a point of interpretation of the protocol arises, then you return to us. That will be advantageous in that there will be room for other matters in the East African Court of Justice to be handled, while the national courts implement the economic rights under the Common Market Protocol, and that's direct jurisdiction. The more complicated one, of course, are those matters where the East African Court of Justice has interpreted clearly the treaty. And this is very, very obvious in matters involving good governance under Article 6 and Article 7. There's been a lot of interpretation to the extent that the national courts can now simply implement what has been implemented. And those matters don't have to go back to the East African Court of Justice. And if they do, the Court of Justice could assist us by saying, please go back, because we have interpreted this. And if it is a matter of interpretation of the treaty, you can come back. This is the way in which our community law can grow, in the same way that is the European Court, the European law has grown. My friend here has been engaged in training, and I know he's very, very particular about this. But we think that this is an important matter for accessibility to the court, which will ease matters at the court, the East African court level, as well as enable East African community law to implementation. Thank you very much.
Okay, thank you. And I want to retire for the time being and hand over to my colleague Evans, who will probably start with my Lord Chibori on answering questions.
Good afternoon. That's not energy that we expect in Nairobi, Kenya. We need to have a little bit of energy. You see us on the streets, we're always energetic to go, So we are going to do the Kenyan way. Moja, mbili, tatu. The Republic of Kenya is here. We're going to have a little bit of energy. My good friend, the Lord Justice is here. My brother, you're going to run, Kenyans run, Thank you. Help us here.
I don't have much to say on the question that is on the table. It has been answered already. What I would only add is to say that when we appointed judges, we already know the job hazards, what comes with that job. By the time you take the oath, you are now accepting. Unlike even at the ESCJ, where judgments are all written as judgments for the court. For some of us from national courts where we sit, you write your judgment under your hand. This is a judgment of Cheborion. And you give your views, many times criticizing the state, and you expect all these sorts of reactions. What were you saying in this? Sometimes they say, oh, we're going to cut funding, and so on, and it has happened in other jurisdictions. But we understand this, and we have to live true to our oath. Now, but why I got the microphone was, there was a question which was asked by Don on what we need to do to find a solution to the issue of funding. What intervention should we do? And in my mind, I was thinking about how we can get in touch and dialogue with the chief executives of these partner states. Because it looks like most of them wield a lot of power to be able to decide how funding can be spent in their countries. I recall that when I was one of the council members in ELS, I think I was Secretary General, and Don was our CEO. We put forth a strategy. At that time, it was not issue of funding for the court. The issue was on issues of good governance in the region, where there had been challenges in some countries. And we devised a strategy of the council members visiting each head of state. We went around all the partner states and met the heads of state and put forth some of the issues we thought were critical. I thought this would be a strategy that can be adapted now, where ELS comes forward, because it is free to talk. Sometimes we judges were limited with the issues of independence. You are talking to a litigant, constant litigant in your court. You can't talk as much as maybe a person from civil society can do. So that's one area where I thought maybe ELS can come in and be able to move and have really discussion with the chief executives of the partner states. Thank you.
A small one. You know, what my brother professor was saying, that even the African court, when the matter is coming from your country, you don't go there. You shall be threatened back home. You will go back home. Be careful. And even many meetings like this one, it say you will remember the SADC. But you know, even back home, there are people who thought by us being appointed to the East African Court of Justice, we shall be there to be their ambassadors, even in court. So what the professor is thinking, even in our country, there are people who think like that one. We are losing our cases. You are there. You are not assisting. But we are also mindful of our oath. So we are 5, for example, in our appellate, we are 5. So I'm not there to defend where I'm coming from. I will be a stupid judge to go in a bench and then start defending the country which made the rubbish there. So to me, what I want to say is this. For example, like me, who have been appearing to this court, since the Burundi joined the community. So there are cases which I was there, even before I was there. I can't go there. That's for any reasonable judge. But for any matter which comes from there, I'm not an ambassador of my republic in that court. Because at the end of the day, my tenure is there. It will end. But my life and my professional will continue. So we're not there to defend our countries. We're there to defend the treaty and also the issue of surrounding the interpretation of the treaty. Otherwise, if you go there to the East African Court of Justice to defend your country, it is better you leave. And the area should be the sooner.
Okay.
Yes.
Thank you very much. A hand of applause. Santi sana. We need to make some progress. There's an article online. You can Google this, download it. The Courage of Principle, Digang Moseneke. It speaks to what the good judges have been addressing us on. the courage of principle. Now, we want to make some progress. My brother, hold on to your microphone. This is how we proceed. The ladies here have not spoken. I want to pose my question, and the ladies on that bench there, the two ladies, then we'll come to the SG here. Question is here. What opportunities exist for advancing human rights through litigation at the ESCJ? That will go to the lady in glasses like me. We wear glasses, so you'll help me answer this. Then the lady next to the extreme corner will handle this for me. What are the primary challenges faced by litigants in bringing human rights questions to the court? We start with the lady here, then we go to the lady on to my right. 2 minutes quickly, then we move to the next table here. Yes, we start with the lady. Yes, the one smiling. The microphone is hers. If you don't have any answer, just say, hello, I'm from this country, good to see you.
Hello, my name is Buzaire Angel. I'm a member of Rwanda Bar Association. So I'm so sorry I came late, and I would like my colleague to help me by, you're not a lady, but we can just contribute, yes.
Well, thank you. May I kindly request that you repeat that question?
The question is this: what opportunities exist for advancing human rights through litigation before the ESCJ?
Oh, thank you so much. I'm Nicholas from the AG's office, Rwanda. The opportunities of enhancing
human rights
through litigation. Litigation. Well, much as the East African Court of Justice, I would just use this word, maybe I'm sorry to use that, pretends not to have jurisdiction over human rights issues, but on the other hand it has, because it just handles such matters under the umbrella of good governance and rule of law. So, as the East African community population, you find that most of the cases or issues just go around human rights issues. But this court has been keen enough and smart enough to handle these cases within the umbrella of rule of law and good governance.
Okay.
And has taken a good step to settle these matters and make decisions over them.
Okay.
So, sometimes we find that lawyers maybe or litigants have tried to file cases making pure human rights issues. Sometimes there may be, because I come from the AG's office, I'm all the time a respondent. I've never had a chance of becoming maybe an applicant. Sometimes it's very minimal. But we usually pose preliminary objections, alleging that this court lacks human rights jurisdiction. By the end of the day, you find that so the case is litigated, adjudicated, and decided under the umbrella of rule of law and good governance. So we should never be threatened, or we should never fear to advance or file suits of concerning human rights issues, but under the Article 6, 70, and as such I've always been doing.
Okay.
And in fact, I would like to take this chance to appreciate my colleague, Emily Oceano. She's really good. She's really given us hard time. And I really like that. I like that. I congratulate her today. She's a good litigant. She's a nice one. Really, I really appreciate that.
Okay.
She's a human rights activist and a very good lawyer. She, of recent, in fact, she filed a case against all partner states, challenging that the partner states have not taken their responsibility to pay their dues or pay their contributions, which has paralyzed the functionment and the operation of the community and the court in particular.
Okay.
So, secondly, the other chance of filing human rights suits, we can use our law reports. The East African Court of Justice law reports are there and placed, and they really have a lot of material in them that can guide us to file such cases before it. Thank you so much.
Thank you very much. We move to the lady at the extreme corner. 2 minutes, my good friend, my sister. What are the primary challenges faced by litigants in bringing human rights cases to the court? Over to you. 2 minutes, please.
Hi, I'm Kabagambe Joel from Honda Bar Association. Can you repeat your question, please?
What are the primary challenges faced by litigants in bringing human rights cases to the East African Court of Justice?
For sure, never be a litigant in this court, but I can ask my friend and my counsel, Jordan, to answer this question. Thank you.
Don't dare. We are trying it with the ladies. They're giving the men opportunities. My brother, there are 2 minutes.
Yes, thank you very much. Previously, I had requested time to comment on the question that was asked by the previous host regarding on whether the judges should recuse themselves from when they meet matters or they sit to adjudicate matters involving their countries of origin.
Allow us to skip on that.
Yes,
We'll do it over lunch. So we go to the question.
I'm going to answer the question that was asked.
Yes.
One of the things, the challenges that are faced by lawyers bringing matters of human rights to...
Yes, continue.
Yes, to the court. One of it is, like my colleague mentioned, was on the interpretation of the treaty or the interpretation of the act of the ESCJ, where they mentioned that it is not very clear whether the court has jurisdiction to adjudicate matters of human rights. That has been the fundamental challenge that is faced by several lawyers. Because we have to understand, unless you have had experience, like my colleague mentioned, experience with these kind of cases, it is always going to be problematic in terms of seizing the court for such cases.
Okay.
Another thing is I'm going to mention is in terms of bringing forth the evidence that is required for human rights violations. We've had cases where we've had the issue of giving evidence. Most of the evidences we have is based on digital evidence. So bringing together the evidence against the states, because most of the respondents are states. So being in a position to raise the evidence to prove the case has also been a problem for bringing forth matters of human rights.
Okay.
Yes, I think those are the fundamental challenges that are faced by lawyers.
Thank you very much. We go to is it the SG next to you, Vice President LSK, the lady in green? This is her question. Good afternoon. I'm told it's Mwiriwe in Rwanda, Kigali. What steps can be taken to simplify the filing procedures before the ESCJ? Steps to simplify the filing procedures.
Steps to?
Simplify the filing procedures before the court. Or anything in your mind. Or how can we make legal representation be improved before the court for individuals and entities? How can we make it simple for people to appear before the court?
For people or for lawyers?
Lawyers, non-lawyers, yes.
I'm going to... someone said about using using email to file cases before the court. Yeah, that is the idea which comes to my mind.
Electronic filing and all that.
Yeah, electronic filing.
Vice President LSK, I saw your hand up.
As a matter of fact, she was just going to give me the mic only. She didn't know my name. My name is Mohora.
It's a small joke I tell from time to time. I don't know why no one is laughing at it. One of the steps that can be taken to improve access to the court is embracing e-filing, which my sister is talking about. And the assessment during filing of substantiating the claims is something that can be made within a service charter that is at the shortest time possible, because I heard also we were talking about matters that are filed under certificate. That will then enhance and improve the turnaround time for judges to make their finding. But now, since I have the mic, allow me, because I've also been banning, and I have to earn my per diem CEO, is that the question as to whether a conflict arises, especially for the office of a judge, at any given point of a jurisdictional question, is one that is self-internal. Once you take the oath of office, and I am glad that the President had mentioned this, is that you are bound by that oath of office. It doesn't matter whether the matter is coming from your country of origin or where you are coming from. The question as to conflict will arise if, as a judge yourself, the matter you are determining will have a direct impact on yourself, or you'll have a benefit on it. But there is a question, and let me stand, because the question was offered by a judge, is that when it comes to the question as to pleadings and the quality and value of pleadings, I want to make that intervention that even as judges and lawyers being, the agents that are specifically addressing the court within the main frame of the value of the pleadings, it will be important as a court to also give feedback. And the feedback doesn't have to come back in a separate administrative notice or letter. It can even be within the judgment itself. Ogada, I'm finishing. Okay. Because then, it is only then that a litigant can understand their impact to the court, and it's not in bad faith and not malicious. In fact, many judges give feedback, and on this specific area, you learn better when the judicial officer actually guides your hand in moving forward. And I am proposing that as a repository, each member state or each bar has a complementary registry with the court, and this can be done with the online APIs. If different bars have that, I know in Kenya we do have ours, so that we can always compare the law reporting from the court itself as well as the court reporting from our side. I'm saying this with a lot of emphasis. I know I'll not get another opportunity. Ogada, you're looking at me with the geography of your face changing. Allow me to just finish so that I don't also hurry up. It is important to dissect, and my brother from the AG, sorry to put you on the spot, we are all lawyers, even the judges are lawyers. Before you start in the career progression you're on, you can be an instrumental factor in addressing the challenges that we bring to the court. You don't have, and I know my very good teacher, Professor Githu Muigai in Kenya, says that you don't have to hold a contrary position just because you serve on the other side. When the matter is straightforward, advise your client. And advising the client does not mean taking a contrary position to what, advice is that if your client refuses to take the advice, that is up to them. It is not on you.
All right.
The judiciary in Kenya, I want to put them on the spot as I wind up, Ogada, is that, sorry for saying wind up many times and I'm not winding up. We know, like the judiciary in Kenya, and I'm sorry on their behalf, they say the court does not have jurisdiction over matters that touch on the Supreme Court, even in review. And then when they are taken before the High Court in Kenya, they say the matter is pending before the ESCJ. I don't know how we want to resolve that conundrum that you refuse jurisdiction, but then when it's affecting you, say, hold on, this matter is before the ESCJ.
Thank you.
It's a conundrum of not.
Thank you very much, Mr. Vice President. I want us to be very quick. We will go to, before I come to you, my brother from Tanzania, we want to hear from our president, the vice president. Your question is this. We will take 1 minute from you too, Saul Makbul. My brother, here, the president of the ELS, Saul Makbul, and to the vice president as well. Are there specific human rights issues that the court should prioritize in its jurisprudence? Saul Makbul, to you each, 2 minutes each from the president and the vice president. What should the court prioritize in terms of human rights?
That's a surprise. But I think that's a question now to the to the bar itself, we as the practitioners who appear before the court, in terms of the matters that we have to present before the court. And also for the court, I can say in terms of the matters that are pending before the courts, which are of great importance, some under certificate filed by ELS. So those that are under certificates need to be attended to as soon as possible.
Okay.
And I believe at the office at the registry, perhaps can assist the judges in identifying these matters that are of great urgency across the region. Thank you.
Shukran. Vice President, we've not heard from you today.
Thank you, Mwalimu. I don't think I'll have much to add. You know, after the President speaks, we just conclude. But what I'd say is this. EAC in general, we have a population that is increasingly aware and increasingly informed. So we, the stakeholders and the court, let us do everything within our power to meet the expectations that will help us consolidate our relevance. And once we have that, everything else that we want to advocate for, including budget for our year, all those challenges will be met. Thank you.
Thank you very much. Mr. Lenguru, only 1 minute as we wind up. I'm sorry, we are hard pressed for time.
Yeah, thank you.
1 minute as we wind up.
Just quickly on about the issue of limitation, access to the court. I know the court is doing well in terms of not referring to exhaustion of local remedies as compared to the other courts like African court. But there is one issue of limitation, which actually, as human rights lawyers, we feel like that is it's a problem when it comes to access to the court. Human rights violations are perpetual. That if things that we should not give us 2 months or 1 year, whatever. I'm asking maybe the judges who are here and other litigants, do you think, do you see this the time maybe we should actually come back and discuss whether we can remove the issue of time limitation for human rights cases?
Thank you very much. I saw your hand, Attorney General from Rwanda, President Batoniye Burundi. Please forgive me. We have been told that our time is up. We will continue the conversations over lunch. Please pair up and let's continue with that conversation. Allow me to end so that we respect our host's guidance. Murakoze cyane. Thank you.
Well, we have come to an end of our second session of deliberations. We now retire for a while so that we take our lunch, after which we will have the last session of the day, which will be presided over. It can't be moderated. It has to be presided over because the one coming to take over is a judge. Judges normally preside over proceedings. They don't moderate things. So it will be presided over by my Lord Justice Neziriayo, who is the former Vice President of the East African Court of Justice and the former Chief Justice of the Republic of Rwanda. So we now break for lunch and then come back for the last session. Then we'll be left in the hands of our acting registrar, who has acted for so long anyway, until I wonder, is almost becoming like East African Court of Justice, which since its establishment, which is more than 25 years ago, it is still in its temporary seat of the court.
Thank you, Professor Ruhangisa. Let's give Professor Ruhangisa a big round of applause. I was reminded earlier that we probably should have given you a keynote somewhere in these proceedings. But thank you for that wonderful moderation. We are going to proceed to lunch, and then we'll come back for just about an hour to conclude the session and get our recommendations, which we can then take forward. So allow me to ask you to take the shortest time possible. Lunch is served at the restaurant. I have to confirm that. Actually, maybe you can confirm the venue for the lunch. Okay, he says we follow him. So my Lord the Judge President, Honorable Judges, I wish you a good lunch. Bon appetit. Let's be back by 2:15 at the latest. Thank you.
So now you'll get me a number before I go, so that when I come next time, when I come next time, then I'll be able to meet you, and then we talk a lot. Okay?
Good afternoon. Microphone check. Microphone check. Let's have our seats. Let's have our seats. Ladies and gentlemen, a couple of delegates will be leaving this evening. We have to finish by 3:15. We have our moderator for the next session present, and we will want to invite him to come and lead us in the process. Our next moderator is the Honorable Retired Chief Justice of the Republic of Rwanda, Chief Justice Faustin Neziliayo. So we will invite the CJ to come and guide us through this. Chief Justice, welcome, sir, to guide us.
Thank you very much. Good afternoon, distinguished participants, dear colleagues. It is really a privilege and an honor for me to be with you this afternoon. I could not make it this morning, but I was told by the President of the East African Court of Justice that the session went very well. But also the CEO of the East African Law Society. So it is a very great pleasure really to be with you. I was just greeting some colleagues, but also some learned friends. The ones we were together when I had the privilege to serve as a judge at the East African Court of Justice, but also my colleagues here in Rwanda when I had the privilege to serve as the Chief Justice of Rwanda. So talking about efficiency of a court or a judiciary is very important, of course, to assess its performance. Efficiency is part of the broader in the broader context of judicial performance, and should not be confused, as we know, with judicial effectiveness. Although, when I see the key point that we'll be discussing this afternoon, I've seen that we will be, passing from efficiency to even to effectiveness. Judicial efficiency, as you know, incorporated various aspects, including the timely resolution of cases, the avoidance of delays, and the effective utilization of judicial resources. It can be defined as the capacity of the judiciary to process cases while optimizing the use of available resources such as time, money, personnel, and infrastructure in order to effectively and expediently deliver justice. It is what we are familiar with when we are talking about resource optimization. So we know that there are some, I am not making a presentation, but I am just introducing the topic we'll be discussing this afternoon. We know that there are several indicators that can be utilized to assess judicial efficiency, what we call the disposition, for example, rates, the clearance rates, the incoming caseload, the pending caseload. Those are indicators that can be used to assess the efficiency of a court as such. But we know that we more and more use clearance rate as a clear indicator of judicial efficiency. And we know that a higher clearance rate implies that the judiciary manage to handle more cases than it receives. And at the end of the day, if it handles more cases than it receives, it will have spare time also to go through all the cases. And what we have seen and what we will be seeing, unfortunately, is that with our courts, it is not the case. It didn't, for example, if I take the example, for example, in 2024, the statistic I got from the registry indicated that there are more than, there are 243 references, 2 claims, and 35 applications that are pending before the first instance division of the court. As far as the appellate division is concerned, we have 7 appeals and 1 arbitration and 8 applications that are pending, waiting to be disposed of. And I don't know if the information is accurate, but I am told that the oldest case pending before the court was filed in 2015. Is it right or okay? I don't know. But that is the information that I got. And as far as the clearance rate is concerned, in 2024, the court got 66 references. 66 references were filed in 2024. 13 references only were determined. That is, at the first instance division. And at the appellate division, 7 appeals were filed, and 1 appeal was determined. I don't know if it is accurate that this one as well. And 31 applications filed, and 14 applications determined. So that is some kind of, to put our discussion into context of what is really the current situation and what are the many challenges that we have as far as key points that we'll be discussing. 1, ESCJ funding, judicial appointment to the ESCJ, the permanency of judges, the jurisdiction of the ESCJ, but also of course, very important is the implementation of courts. And if I may talk about this implementation or the execution of courts, of decision of the court, we know that for an international court like the East African Court of Justice, the way its decision are complied with is very, very important. The ESCJ, like any international court, is facing these challenges, essentially when an international court cannot be influential and cannot play its impact as far, for example, regional integration is concerned, if its decisions are not well executed. Because the court is becoming what we can say, it is becoming toothless and it is becoming ineffective. That is it is not what we want for our court. We want our court to be, of course, effective. And the topic before us, distinguished participants, honorable judges, honorable senior counsels that are here, dear participants, this is a very challenging time to discuss our topic of this afternoon. And we have about an hour to discuss on the key points that I have just highlighted. If I may repeat, we'll be discussing on ESCJ funding, judicial appointment to the ESCJ, permanency of the judges, and the jurisdiction of the ESCJ, and the implementation of its decision. Of course, this matter may be cross-cutting with other points that you discussed this morning. Of course, we will be strengthening our discussion even if we refer to what has been discussed this morning. So I am here as a facilitator, and I will be very glad, of course, to take any comments, any contribution, as far as we are trying to find suitable way to make our court more efficient. Distinguished I move to you so that you can enrich the discussion on this very important topic. Thank you very much. So the floor is yours. And if I may guide, we can maybe go subtopic by subtopics. But I think sometimes these topics are cross-cutting in such a way that I can't say, okay, let us talk about the funding aspect without joining it with the appointment of judges, because if we have funds, of course, we will be able to have more judges. So we may take it one point and after another, but we can also be guided to follow, the key aspects that we can want to point out. So be flexible in the way. Yes, please. Even if I know you, please introduce yourself to the audience so that we can interact efficiently.
Thank you. My name is Ugada. I chair the Rule of Law Committee for the ELS. My question would be generally to the audience and specifically to the judges. What role can technology and digital transformation play in improving access to justice and increasing the efficiency of ESCJ operations?
Thank you very much for your intervention on technology. How can we leverage technology in order to make our courts more effective? Senior Counsel Dea.
Thank you very much, my Lord. For the record, my name is Donald Dea with the Pan-African Lawyers Union. I agree, my Lord, that there are a number of things that are intertwined, and we can't touch one without the other. So, for instance, the strong recommendation from the bar, at least the private bar at this stage, is that we should move towards making the judges full-time and resident at the seat of the court, whether the temporary or eventual seat of the court. But this has to be tied with making sure that the remuneration that is then promised to them, because these are people who have lives, they have spouses, they have children, they've got things they're doing, that we also work on the remuneration, and the remuneration is assured. We should not force people to be sacrificial lambs. So I think that's something that really has to come out. Then there's also the issue which, because in the morning we did speak quite a bit about funding, and I think some very strong recommendations were made, including engaging the heads of state directly, and including engaging the East African Legislative Assembly, especially the Legal Privileges and Rules Committee. One thing that we did not touch on in the morning is the issue of implementation of the decisions of the court. And of course this court, just like other international courts and tribunals, suffers this challenge of decisions not being implemented and sometimes flouted. So what I would like to recommend to this group is we consider whether we want to go the way that the African Court on Human and People's Rights and also the African Commission on Human and People's Rights went with their 2020 revised rules, where they created a specific chapter in the rules that provides for procedures for assuring implementation, including the possibility to hold implementation hearings where the various parties to the case can come back and report on what has been the level of implementation. There might be some best practice that we can get from the respective rules of the African Court and the African Commission. Thank you.
Thank you, Mr. Day, for your contribution. I think after the two interventions, I found that it will be very more effective and efficient, to go topic by topic. I think I can see, because we can mix them up. Let us start with the very, thorny issue of permanency of judges, because it can be cost-cutting with many others. So let us start with this matter pertaining to the how the court is now an ad hoc court, and we would like to have it permanent. And what does this imply? What it imply in terms of, what are the conditions that have been secured for judges, but also what is required. So let us focus first to this first point related to permanency of judges. It is one key point we had to discuss. And as Mr. Deya said, what with regard to the remuneration of judges, for example, and what strategy can be adopted, for example, if we want this to be adopted by the relevant organ of the East African court, of the East African community. And of course, there is the question that was raised with regard to leveraging technology. How can we best leverage technology for more efficiency of our court? But let me hold this one. I will be coming to it later on. And let us focus on the permanency. The first key point to discuss is the permanency of the court. What are the main faults that we can advance in order to tackle this very thorny issue? Permanence of the court. One was raised by Mr. Deya, that is remuneration judges. But other points that we can take into consideration? Yes?
Thank you, Justice Ntozio. My name is Okubo, former registrar of the court. As we are sitting here today, 24 years since the court started, the court is still transiting. And it is the only organ of the community which is still transiting for 24 years. A child who was born in 24 years is now finished university or even has a child, but the court is still transiting. Article 124 of the treaty. But I don't believe the court, because that treaty then gave the responsibility to somebody else, the council, to determine when the court should be fully operational. It's out of the hands of the court. But that does not still mean that the court cannot do anything. We indeed tried doing it. Maybe, Judge, you can remember. I don't know who else is here. Some of them, when they came on the tail end of it. I did a paper to the council trying to justify why judges should be permanent. And I gave all the reasons, including financial implications. The council took me back, forth, until at the end, they had no reason to take me back, forth. So what did they do? They said, now send that document to us, the headquarters. I ran up my office and sent it to the headquarters. Came back to the hall and gave every country a hard copy. And they still told me, we said you sent it to the headquarters. I said, yes, check your emails, I've already sent there. They had no more questions. And when it came to financial implication, the difference of what the court was currently incurring and making the permanent was only $15,000. It included all the budgets, the vehicles for the judges, the drivers for the judges, everything, $15,000. And we explained as much. So my suggestion is, fortunately, the acting registrar was one who used to take minutes of the council. She's aware of that decision. The court should push that document to be brought back to the council again, because the treaty gives them the authority to determine when they should be permanent. Maybe that matter should be brought back to the council again and be pushed to see how judges can become permanent there. That will then solve many other problems like of delay of concluding cases. Thank you.
Thank you, Mr. Okubo, for these interventions and the very pertinent point that you made to the practicality really of making the court permanent. Some of us who happened to be here when, during the ESCJ conference, you remember that we discussed about this. And the reason why I am bringing this back is that we had the opportunity at this time to be with, decision makers of our ESCJ. We were with attorney generals, we were with the chair of the Council of Ministers and other member of EALA. So I think we borrow from the recommendation that were taken at that time because they were so pertinent in order to push for the agenda of having a permanent court. But the strategy that Mr. Okubo is also advising, it can be also taken into consideration. Other thoughts, other intervention on this very topic? So are we exhausted with because I don't want to be pushy, but when I see some of you senior counsels here, eminent judges that are here, I am tempted to call upon one or another, but I will not be doing this. Yes, Justice.
Thank you so much. I think the issue of permanence of judges has a big bearing on this topic of efficiency for expeditious justice delivery, and touches on other topics that were discussed in the morning, especially the one on reduction of backlogs. I remember sometime back in Arusha, in one session, the ESCJ First Instance Division was able to dispose of more than 25 matters in a single session. Now, when you talk about backlogs, you mentioned about close to 300 cases currently over the first instance. Now, if we are able to dispose of more than 25 cases in a single sitting session, you can imagine if the judges were permanent. Wouldn't be talking about backlogs now. So I think it is so crucial to continue pushing for those who take decisions to consider this matter seriously.
Yeah, thank you, Justice Muhumuza, for this intervention, especially pointing out what the court is able to do when it has the means to do it. And I think we take note of, yes, Professor Simpebwa.
I think we all know we agree on the ideal that we should have a judiciary, a regional judiciary, which is permanent. But we are also aware of the challenges which have been mentioned. We want to have this judiciary that is properly funded. I'm glad to hear from Worship Okubo that there was a study that culminated into a recommendation to the council. And that recommendation pointed out that the difference in expenditure between funding the judiciary that was not permanent and the judiciary that would be permanent would not be great. Now, I'm wondering whether the factors that existed at the time when that study was made, for example, the number of judges on a temporary basis, the expenditures that were being made on them, the funding generally of the community, whether those factors have not changed in order to necessitate a revision in that study, which we can recommend so that we have a basis for subsequent recommendation for a permanency of this court. Because that is the main worry. We don't want to have a judiciary that is not properly funded. I know that even the current judiciary is not funded, but at least our judges have a fallback position. If there is no money, they go back to their national duties and sit back. Of course, that's not what we want, but that's a fallback position. It wouldn't be existing when we have permanence of the judiciary. So Worship Okubo is in the best position to advise us on whether that report that was made is still completely valid or needs some revision. Thank you.
Yeah, thank you, Professor. And especially with regard to updating really the study that has been carried out, let me hear from the acting registrar and the former registrar of the court. What can it take to update the study? Because that is the starting point, as the professor rightly pointed out. We have to have the data, and updated data can, of course, inform a better decision. Acting registrar, do you want to? Yes, yes, please, Professor.
When they stand, they can respond.
So I am sure that you have also institutional memory. That is Professor Ruhangisa, who happened to be the inaugural registrar of the court. Professor? Mike?
Sorry. The acting registrar would help us, and where possible, His Worship Kubo can also chip in. We would like to know the status of the Judiciary Administration Bill. That was a bill which initially had almost all these concerns, the itemized. Did it face a natural death? Was there any suffocation somewhere? If possible, how can we revive it? And that brings us to the point which Don Dare was introducing to us in his comments, that maybe we needed to have members of IALA. These are the people who assist us in lobbying. In the past, we used to suffer from the same suffocation by the Secretariat until we had to form a certain kind of solidarity to speak for each other. And as you know, the court has the only mouthpiece was the registrar. And lobbying through IALA. Later now came in the Law Society. So these are the people we cannot afford to part company with. Maybe the registrar can tell us what is the situation with regard to this bill, which was supposed to contain all these details.
Yeah, thank you, Professor Ruhangisa. Christine, do you mind making your contribution on this point?
Thank you very much. Indeed, there was a bill on the enactment of, there was a bill on the administration of ESCJ, and this was a private member's bill. Unfortunately, it collapsed. But as a court, we have been involved in discussions on how to initiate this bill. However, we thought that it's not something that should be left only to the IALA members. And the plenary of the ESCJ is currently reviewing what had been submitted initially or tabled before the Parliament, because we have found that the provisions that were included are actually, they do not apply to our current situation. So we are already working on that to come up with a bill that shall serve its purpose. And we are also, or we have already given due consideration of the need for inter-organ collaboration to actually fasten this. But I think this is one of the resolutions that should come out from this meeting on the urgent need of an ESCJ Administration of Justice bill. Thank you.
Thank you, Your Worship, for this contribution. But can we have a time frame as far as the internal discussions are concerned? Because from what you said, you know, the ESCJ has yet to come up with, you know, the review of the oral document in order to make sure that it is updated. Can we have any time frame?
This matter was considered in the last plenary,
Okay.
and we are expected to report at the next meeting of the plenary.
So
I believe by the time we meet again as a forum, or even before, we'll be able to have an update on this process.
Mm-hmm. Yeah, thank you, Your Worship, for this intervention, and especially for updating us on what has been done internally in order to make sure the ESCJ administration bill is ready. Also, I think the commitment for the ESCJ to do its the needful in order to have the comments, and so that a document is prepared. So, but I feel that can we formulate the recommendation around this? So in terms of time frame, and because now if I may, the ball is in our court now. Because if there is something that has been to be done to the oral document in order to update it, so if it is this has not been done yet, so we are the one to blame. If blame is the right word. Yes, Principal Judge.
Thank you, moderator or facilitator, for giving me the floor. There are a number of things to consider when we discuss the issue of the ESCJ's financial and administration bill. One is that the bill that was developed was a private member's bill, so there is need to collaborate with the IALA in terms of going forward. So if we have to initiate any processes, we have to lobby IALA to be able to concede or agree with the recommendations that we're going to be making in that new law. But secondly, some of the issues that need to be in that bill requires amendment of the treaty. And that includes, for example, the issue of permanence of judges. If the treaty is not amended, then we also have to lobby that Council either develops a law or makes a declaration that the court is fully operational, because those are the conditions set in the treaty for the court to be permanent. But as you said, there are also a number of studies that need to go alongside the development of that law. As the others have said, there are conditions which have changed since the initial study was made. The member states of the EAC, I think by then were only 5 or maybe 6. Now we have 8 members. And we should also understand that when you're discussing about the issue of permanency, you cannot separate it from the issue of funding. The major challenge that we have, even now, when the court is ad hoc, is funding. You cannot schedule matters for hearing if you don't have money. Even if you have to do them online, there are finances that go alongside online hearings. So we need also to find ways on how we can adequately capacitate the court in terms of funding. Because like in the last financial year, my colleague here said we were able to dispose a number of matters in one sitting. But how many things did we have? You know, the council had allowed the court to sit 10 times. 10 sessions, 5 for each division. But you only managed 2 per division. Mm-hmm. That means if we had sat 10 times, the number of cases that we are now discussing about, as backlog or as pending cases before the court would have greatly reduced. So if, for example, even now, when we have an ad hoc court, if we are able to sit in all the scheduled dates, we are able to dispose quite a number of matters, including urgent matters. And given this opportunity, I should also maybe I should also address the issue of urgent applications or urgent references filed before the court. Mm-hmm. The rules of the court allows disposal of urgent applications on urgent basis, but the rules are very stringent. Once you agree that this matter is urgent, you only have 30 days to hear and determine that application. You can only do that if the court is permanent. Or you can hear, or you can do that if you have all the facilitation that you require within that urgent period. So there are quite a number of issues. This forum will also assist us to pave way on what we should do to ensure that justice delivery is done to the expectations of the East Africans.
Yeah, thank you. Thank you, Principal Judge of the East African Court of Justice, the State Division. Of course, when it comes to, we understand what a private member bill means. It is just one originating from an MP. So we don't know if the opportunity will be there or is still existing for someone to be interested in that matter. But I think we have to rely on what we can do. What can we do in terms of pressure or lobby, you call it, to the very relevant organ in order to push the agenda of the permanency of the court. So, as the principal judge rightly pointed out, it can be also in the, in the competence of the council just to declare, as the law says, that the court is permanent. But why are not doing this? How can we make them, how can we continue to push for this issue to be tabled? So I'm sure that is the exercise we are dealing with for today, to see how can we strategize to make sure that what we want can be scheduled and discussed with by the relevant organ. Of course, the issue of how to deal with some urgent matters like urgent applications, the like, I want to tie it up with the what one senior counsel pointed out with regard to leveraging technology. I'm sure you discussed this morning. I understand that there are some, apart from the revision of the rules of procedure that has to be done, but also there are many, many activities of the court that can be dealt with using technology. And I am sure COVID has shown that it is possible not to come to Arusha, for example, for scheduling conference, not to come to Arusha for some applications that can be dealt with using online or remote hearing. So that is the issue also that, but this can have also an implication. That can have an implication on the budget that can be used if people have not to travel all the way to Arusha to have their case heard. That will be also a very important issue to consider. Not necessarily considering that you have to be in Kigali for the session, as you have just finished your session in Kigali, but you could be in South Sudan and appear before the court that is sitting in Kigali. So those are aspects that are linked also to the funding of the court. But in order to move forward and tackle the next one, which will be implementation of the court decisions, I can take from the audience that one very salient point to take into consideration is for the court to be, for the permanency sake of the court, there is a need to review and adopt the East African Court of Justice Financial and Administrative Bill. And for it to be done, there is a need for updating, having a fresh information and updated information with regard to the status of the court as far as its adjudicative job is concerned, and what it could take in order for the court to be permanent. But the audience was referring also to the intervention that could be done by a complementary intervention by His Worship Okubo. If you may jump in, if you may, you have the floor. If you see that there is something that can complement what Her Worship of the court, Mutimura, said, but also the intervention of Professor Ruhanyisa, so that we can conclude on this point. Do you want to chip in?
Yes, thank you. Just briefly, yes, the circumstances may have changed now. Even when that bill was in EALA, members were not as many. But I think the idea then was like, let us get the bill through. We can always do amendments to fit into the changing circumstances. But being a private member's bill, then the countries had to be consulted to give their comments on that bill. And I think by the time I was leaving, only 2 countries had made their comments. That technically meant that bill collapsed. It is good to hear that it's being revived, and I hope they will get a member of parliament who will agree to run away with it. Actually, that's what we did that time. We looked for a member of parliament, sold him the idea. He said, this is a good idea, let me run away with this, and we pushed it through. Note that the cost incurred when they are permanent vis-a-vis the cost incurred when they are not permanent, the difference is very small. And that was what we are trying to make sure. What you will gain by these additional costs is...
And move on the second point, key point to consider, which is, I understand that with regard to ESC funding, we can take some few minutes maybe to talk about it, because it is closely linked to what we were discussing about the permanency of judges, the very concern and challenges that have been expressed so far last time, I think, are still valid. But do we have some fresh ideas with regard to the funding of the court, the constraint that we have? Even when we know that there are areas in contribution by partner states. So, yes, please.
I'm trying to think of some innovative ideas of funding, and I look at the court being a regional court, while it may seek some core funding from partner states, but I don't think that the court is also restricted from looking at funds from other partners outside so if a good case is made, perhaps some of these either core fund or support funding may be given. And I think at some point in time this has been explored. If I correctly heard that Raoul Wallenberg at one time was offering support. I know GIZ is offering support to the EAC community in general, but they have a component on access to justice. So if this can be explored specifically by the court, seeking some more funding at least to fund operational aspects of the court, this is something which I believe is doable. There could be partners who can assist. I was looking, I know that the court is considering upgrading its systems and maybe its case management system and things like those. These are things that partners may be willing to offer support. So it's a case of the court itself marketing itself and its services, and see whether partners will be willing to explore some of the problems which can be under normal circumstances. You don't expect a court to market services, but these are different times. The judiciary of Tanzania at some point in time was when we were adopting Tanzli. Tanzli is part of the Law Africa program on open source. The judges were very reluctant, first because it will require all the judgments to be placed on a website without being edited and being put in a law report, where editorial, so the judgment will be in its original form. And in the background of our country, where the quality of English is not as good as for some of the judges and magistrates, that was also a problem. But eventually, the judiciary realized that while it delivers services to its members, service delivery which is fast, which is accessible, where judgments can be easily seen and can be easily uploaded and downloaded, for that matter, will save a lot of time. So it started marketing itself and agreeing to some of these innovative ways that are offered by partners. So eventually now we joined Tanzania, and I believe Uganda and other countries also have joined this system. And now we have, as part of that process, that partner is bringing tools and gadgets to make those accessible. So as part of that agreement, the judiciary of Tanzania was able to secure laptops, scanners for uploading some of the judgments and into the platform, but also to access the resources, to train judges on some of the, how to create head notes and things like those. So it's the initiatives of that nature by a proactive judiciary that also can help. And I'm sure some of these things, even I believe the EACJ doesn't need to buy its own software for even if it's new. It can also see how partners can develop a system for them, or open which is maybe from open source softwares, and develop a system and things like those. So that is something that can be done.
Yeah, thank you.
Thank you.
Thank you. We are running out of time somehow, but we will not finish without really talking about the implementation of the court, because as I said, by introducing this topic, when it comes to implementation, without implementation, a court is not effective. The decision of the court now can't be effective. So, but a colleague in the back does have a burning issue. Just raise it very quickly so that we can have some few times to talk about the implementation.
Thank you, my lord, for the opportunity. I was thinking loudly, how will we fund the court? And
so can you and the colleague also before, can you just state your name?
Oh, sorry. I'm Osiemo. I was of the view that perhaps we might need to introduce filing fees as a way of raising revenue for the court, because initially it was removed so that to encourage parties to be able to file cases. Now that partner states are not serious in funding the court, I think it might be high time to now review the need for filing fees so that an income will come to the court, and out of that income, at least it will be able to run day-to-day activities of the court. Thank you.
Yeah, thank you for this intervention. Access to court, setting up filing fees. This is a huge topic. So I think it is a topic for another day. When it comes to, can we revisit the very current practice of not requiring any fee to someone who wants to file a case with the East African Court of Justice? Can it be a solution for the problem of funding? Can the audience agree that such a topic, subtopic can also, we have no time really to exhaust the discussion on the matter. I think without, running out of it, but I think it is something which touch on the accessibility of the court, and we cannot exhaust the discussion under the subtopic of funding of the courts. What do you think, Your Worship Okubo? I see that you are raising a hand. That I will move after that to the implementation. Yes, please.
Yes, that is which at one time it was discussed. Why can't the budget of the court be budgeted in the national judiciaries, so that the budget of EAC ministry is reduced by the portion that will have gone to the court and go to the judiciaries? They understand us better, so that it is them now who will be remitting the money to the court. I think I was told there was such a discussion, and somehow it was not implemented. Secondly, of course, there is the wider discussion that has been going on about a levy to fund alternative funding to the whole of EAC. But I think for the last 10 years, that matter is being discussed, and it has never been really concluded. It may be something to pursue. And then we need to enforce sanctions. Why do we have members coming? They are not paying. They want to appoint a judge. They want the EALA members to come. Where are they being paid for? In fact, the issue of the money being budgeted coming from the national judiciaries in EALA, on many occasions I'm aware they send money directly to EALA and tell EAC, increase our percentage by this. The Uganda Parliament has sent money directly to EALA. So it is that may be a shorter term solution than even the alternative funding model for the whole of EAC. They understand us better. They know how we work than sitting with people who don't understand how judiciaries work and we are trying to argue with them about the budget. Thank you.
So thank you, Your Worship, for this intervention. Okay, if I may, and sum up on this one, of course, one is to continue for the ACJ to continue to interact with and to engage its partners so that at least operational activities of the court can be funded and acting proactively to make this activity funded by different partners. I think that is something that the ACJ is continuously doing. And with regard to the one issue was raised, one point was raised to see how countries, member states have to, to comply with the treaty obligations as far as the contribution to the EAC budget is concerned, and of course sanctions are there too. And with regard to the possibility of filing fees, I agree. I am suggesting that we can really reserve the discussion to this one when we are tying it with the access to court issue. So 2 minutes, 3 minutes for the implementation of court decision. You understand that we will not be able to talk about the appointment of judges and the like, but what are the main salient matter that we can raise as far as the implementation of the court decisions is concerned? Again, we can borrow from the very good recommendation that was distinguished member of the audience to make some 2 or 3 recommendation or intervention on this very important issue. What can we do to make sure that the court decisions are implemented effectively? I'm sure there are some studies. There is a study that has been carried out, right? Senior counsel there, I know that you were referring to the at these studies. Was it the one you who were referring to the study? But I think there is a study that has been carried out to see the implementation status of the decision of the
recording in progress.
Yeah, Mr. Dea, were you or someone from the East African Law Society? I don't know, sir, who did the study. Yes, CEO ELS.
Thank you, my Lord the CJ, former CJ. Well, we did the study in 2018 on status of implementation of decisions. But while doing the study, we also found out other key issues that affect the operations of the court. So we didn't just look at the level of implementation, we went beyond that. But as per that study, about 47% of the cases at that time that required implementation had been implemented. So we had about 53% that needed implementation but had not. And so that was the main finding from that study at that point. We're hoping we can do another study this year. We're actually talking to partners to see what the status is now. We will more or less compare the study of 2018 and the study of 2025 and see have we improved or not. And by that study, we actually did call all the litigants and ask them, has your matter been implemented according to you? We also call the partner states. So we are hoping we can do another similar study, probably much more improved, to see where we are as a regional court.
Mm-hmm. Yeah, thank you, CEO, and Mr. Dea, yes.
Thank you, my Lord. Just to add on that, so I think a clear recommendation of this meeting would be for all the stakeholders to ensure an updated, comprehensive study of what has been the state of implementation. I do know, even in our own partnerships as CSOs with the Raoul Wallenberg Institute, it's already on our work plan. So I think we can get a clear recommendation that there be a fresh study that updates what the state of implementation has been. Beyond that, maybe, my Lord, is just to repeat again what I said earlier, what we are learning from the African Court and the African Commission, that in the revision of the rules, the court may include a chapter that makes provision for how it can follow up on implementation of its decisions. The text and a bit of a practice already exists, and this is not different from what the two European courts and also the Inter-American Court on Human and People's Rights are doing. Thank you.
Thank you, Mr. Dea, for this very precise recommendation as far as one, include in the rules of procedure when they are revised, provisions on the implementation of court decision. Second, a fresh study to see what is the status, but also of implementation of decision of the court, and make sure that there are recommendations there too. I think that is the two recommendations that we can take at this very stage, so that refreshing what have been done in the 2018 and in 2025, what is the status and what can be done to speed up the implementation. With your permission, I want really to end up here, but to finish with what a colleague raised as a very important matter, and which, as I said, can also help us to resolve some issues pertaining to the funding, to the financial resources of the court. It is, you know, when it comes to emerging technologies, but also existing technologies, we have really to make sure that we are making good use of these technologies. They can help us move forward. Of course, there are some challenges related to ethical matters that we know that can be addressed. But overall, technology has been very helpful. And I was referring to the time of COVID, but also, and even thereafter we have seen that technology, but also many emerging technologies are helping judiciaries across the world and in our region to deal with, especially with their duties to deliver justice effectively and efficiently. So what can be done? Again, we can engage some partners that are willing to help, especially as far as you know, exploring some emerging technology. Like when I am talking about emerging technology, I'm referring to artificial intelligence and the like, and we can see that they can be helpful really to move forward. So with this, yes, a burning issue from your lordship. Yes, please. Can you put your mic on?
One line you have not dealt with, my lord, and it's the issue of judicial appointments, the ESCJ. Currently, and we all know that something that is a live issue, and it's very recently we've had a decision in the courts in Kenya which have basically now rescinded the appointment, the nomination or appointment or proposed appointment of a judge. And currently the first instance division of the court has got only 5 judges. that of course has an impact on the bigger picture when it comes to caseload, workload, backlog, efficiencies. So I think it's a very important thing to hear the thinking of the bar and bench about appointment, so that, we don't have a judge from South Sudan, we don't have a judge from Somalia, we don't have a judge from Kenya, and these are things that impact on the performance of the court. So I think it would be unfair to the expectations of a person who drew this up for us not to, even if we just recognize that it's an issue that was raised but don't discuss. Thank you, my Lord.
Yeah, thank you, my Lord, for this reminder. I think I took it as a given that we support this audience, support the idea of speedy appointment of judges for filling up vacancies that are already that exist in the court. So the recommendation is to make sure that the vacancies that are there are filled up, so that appointments are made. But what about those that need amendment of the treaty? Those will be for another day, especially as far as the appellate division is concerned. But at least at the first instance division, the vacancies, the recommendation of the August audience is that appointment has to be done. The relevant organ has to be to appoint the judges, so that the court, the bench could be complete with the when vacancies are filled out. So let me conclude here by thanking you for the very active participation to this topic. Efficiency of the ESCJ is a matter of importance, because without an efficient court, of course, we will not be heading toward achieving what the court is meant to do as far as fostering regional integration is concerned. But most importantly, before that, administrating justice and our regional contributing to the rule of law in our region in order to have a peaceful and, of course, a prosperous East Africa. So I thank you very much for the very contributions that you generously formulated. And I hope that, the East African Law Society, but also the East African Court of Justice will take them forward to relevant organs of our East African community. Thank you very much for your contribution.
Thank you, my Lord, retired Chief Justice. Before you sit, my Lord, there is a very small gift that I would like to call the President of ELS to hand over to you. Thank you. That was our last formal session. We are going to the recommendations part before this can be fully closed. So allow me to read only the recommendations that have been made from this meeting. These are not final. They are still open to further input, further clarity, before they can be shared with the relevant authorities. The first one the court to review its rules of procedure, including to A, make them more friendly to litigants and litigators in the utilization of the court, and to designate more matters that can be heard by a single judge or judges, and or virtually to expedite disposition of matters. B, consider whether to incorporate a chapter on procedures and processes for monitoring implementation of decisions. I think the best practice is from the ECOWAS Community Court of Justice. They have an implementation department within the court. Recommendation number 2, the court and its registry to be more strict in ensuring full adherence to timelines. This includes filing references or applications, timelines for that, timelines for filing responses, timelines for submitting evidence, timelines for submitting submissions, and other requirements before the court. Recommendation number 3, the court to establish a bar bench committee with the possibility of further establishing a subcommittee on rules. The court will consider whether to establish this subcommittee or this committee and subcommittee in the rules of procedure of the court. So whether it's going to be formal or informal in the beginning. Recommendation number 4, court to consider a dedicated chamber or other institutional matters to expeditiously hear matters under certificate of urgency. Recommendation number 5, court to consider whether jurisprudence is sufficient or more elaborate rules of procedure should stipulate criteria for determining which matters qualify to be heard under certificate of urgency, and how they are to be handled. Recommendation number 7, all stakeholders present, especially in this room, including the East African Legislative Assembly, to robustly engage partner states to ensure adequate and timeous funding to all EAC organs and institutions, and especially the court. Recommendation number 7, that was number 6. Court to ensure that there is an ESCJ sub-registry in each EAC partner state, and to utilize existing sub-registries to promote expeditious disposition of matters. We believe this can be improved on. Recommendation number 8, partners to support the court more in cash and in kind, including facilitating equipment for the court and capacity building for litigators and litigants. Recommendation number 9, lawyers, both public and private bar, and the Office of the Counsel to the Community, to improve the quality of pleadings and submissions made before the ESCJ. This will make the work of judges easier and help in expeditious disposition of matters. All stakeholders, this is number 10, to engage the partner states and citizens to amend the treaty to, this has 2 parts. A, ensure representation of each partner state in each division of the court. Currently, we believe the appellate division, for instance, is not fully represented by all partner states. And B, extending the time limitation for filing references in order to allow applicants sufficient time to explore alternative dispute resolution before initiating litigation. So that is as far as amendment of the treaty. There are other issues on amendment, including extending jurisdiction, but we believe the court already has jurisdiction on human rights and other matters. Recommendation number 11, resource each judge with at least 1 research assistant to ease the workload and enhance efficiency. Recommendation number 12, review the training curricula in law schools across the region to entrench from a young age the concept of a regional legal system and the use of the East African Court of Justice. Recommendation number 13, update the draft ESCJ Administration of Justice Bill, which will provide for the court's autonomy as well as the efficient financial and administrative provisions for that court. Recommendation number 14, ELS Council and other stakeholders to have direct engagement with heads of state and ministers and to present important and urgent matters that promote access to justice, including fully capacitating the ESCJ. Recommendation number 15, the court's case management system to be revamped to enhance expeditious disposal of references. And the last one, a fresh study to be conducted on the status of implementation of the court's decision to create a benchmark for advocacy and to further strengthen the court's standing as a key organ of the East African community. Those were the ones that I could capture and that my team could capture from the discussions today. This can be taken forward. I believe we'll consult with the court to see what is left out and what can be added here so that as we undertake advocacy, especially with the heads of state, we are able to present this as coming from this particular bar bench forum. With that, allow me to call Her Worship, the registrar, who will take us through the closing stages. Thank you.
Thank you very much, CEO, for your remarks. And I want to particularly thank you for working very closely with the ESCJ to ensure that we realize this inaugural bar bench forum. I also want to thank the honorable judges for sitting through this and also actively participating, and for our partners from the bar associations, especially the president of the East African Law Society. Thank you very much for being part of this. Thank you for the support. Thank you to all of you for your contributions. Now, as we come to the end of this forum, I think one of the resolutions that we did not get was on when the future bar bench forum will be. And I don't think this should be the end. I think we need to discuss how to formalize this bar bench forum, because I believe, like Mumbi said, we are better together. And we need to take this partnership forward. So with that, I would like to invite the Judge President of the East African Court of Justice to make his closing remarks. Thank you.
Yeah, thank you so much, Registrar, and the CEO of the Eastern Law Society. First of all, I think being the inaugural bar bench forum, I think the meeting went well. You know, the first meeting sometimes you don't know what is coming out. You come here, we are meeting with the lawyers. Most of them have been appearing to the court. We don't know how it is coming. The resolution, the president of Rwanda Bar Association, when he started, he alluded to the serious issues and the issues. So I think this being the first one, it is my hope that the second one will be even better. What is matter is that the beginning, some of us who have been lawyers for many years, to me, what assists me is that I have been appearing to this court for more than 10 years. So I have been with the colleagues here. Even when I was appointed, I feared that maybe one day after Mr. Dea, we have been fighting many cases against the Republic of Burundi, and me appearing for the government of Burundi. But when I was appointed, nothing happened against me, which was, to me, was good. That was a sign of that we were doing our job professionally. And even some of the lawyers who have been even barred for appearing
in Burundi, when we met in Arusha, because some of them have received accreditation here. I remember when we appeared in Arusha, I opposed them, you should not appear because now we have been banned. But we meet here, which is good. So to me, let us continue doing our job professionally. That is what is very important to me. And this one, being the bar bench, even the judges may fear, what is this relation? But I'm sure, as the registrar said, being together, we can improve. Because at the end of the day, the judges, we will leave the court. And tomorrow we shall come back as lawyers. So it is better, what matters is not what we are doing today. What matters is what are we leaving behind us. So to me, I'm grateful to the Eastern Law Society and their partners, the Raul, Wallingberg, because they have been assisting the court. Because at the end of the day, even when you say the quality of the judgments is not good, but at the end of the day, it's not only the judges, it's the East Africa. Because our judgments are being read by not only East Africans, but even outside the continent. So my brother was saying about the appointment of the judges and the ruling in Kenya. Those people, even those from Kenya, they may need our court. Even if they are in a Supreme Court there, they may need our court today or tomorrow. So let us have a strong court. And you cannot have a strong court without having this kind of relationship. For us, we have spent almost 1 month here in Kigali. We have been enjoying staying here. Tomorrow we shall start another training for 3 days. In the past we were told that la cour connaît le droit. The cour connaît le droit. So when we started appearing in the court, the judges said, la cour connaît le droit. So we have nothing to learn because the judges know everything. It is not true. Judges don't know everything. So to me, I wish to thank you so much, my brother and my sister, the judges, the lawyers, the registrar for organizing, the Eastern Law Society, the PALU. I'm sure, as the registrar said, we must officiate this one. So at least this bar bench, maybe next year, of course we shall discuss with the partners and see how we can formalize this one. So at least next year, we shall also get opportunity to meet. Otherwise, I wish you all the best. I'm sure, as my brother said, the president of the Rwanda Inaugural Society, we got also another time to interact outside in implementing the treaty on widening and deepening within Kigali. We should not only deepen in Nairobi, but also even here, get this opportunity. So, Mungu awabariki sana.
I believe that once the president has officially closed, we are all free to go. I wish those who are traveling back a safe trip. Let's meet again next year. And for those who are still in Kigali, I hope you enjoy your evening. Thank you.
We have a small package for delegates, so make sure you get yours before you leave the room.